One assigned matter, my lord.
Work, yes. To be mentioned,
My lord, with the leave of my lord Justice Rai, may I mention, my lord, a matter, my lord, which was being heard by this bench, my lord, presided over by Justice Banerjee with Justice Rai. My lord, that HITCO, my lord, land matter, Mr. Jishnu Chaudhary was appearing for HITCO for the appellant, and Mr. Surajit Nath Mitra was leading us. My lord, it was substantially heard. Any day, whenever the bench is constituted, if this matter can be, my lord, I'm mentioning upon notice, if the matter can be, my lord, listed, my lord.
we don't know. We can list it before this bench after getting it released from that bench. Otherwise, we can't promise. You have no idea how much under how much pressure we are. It would be better for you. I know it was substantially heard by that bench. It would be better for you. You consider that. We can sit, release. For that, it will take 1 minute.
Yes.
And this will be then the regular bench again.
I'll just have a word with Mr. Mitra.
Have a word with, because otherwise we can't promise when that bench will be constituted for the purpose of hearing.
I was even apprehending that. I told my client, my lord.
Heard in part. Was it marked heard in part?
Yes.
Huh?
Yes.
Assigned. So it has to be released again. Consider come back.
I'll come back.
My lords, we mentioned a matter for inclusion, my lord, in the list. Deeply obliged, my lord.
Right? Non-commercial तो आज के
Wait, please, my lords. Waiting for the respondent in the matter. The issue which is fallen for consideration is whether the court deciding a Section 9 petition in an arbitration.
You are the petitioner in Section 9.
We are the petitioner, my lords. What will be the guiding factor for a territorial jurisdiction? Will a territorial
Still metropolitan bypass?
My lord. The judgment I'm going to refer to and start my submission with, my lord, I'll try and keep it restricted to 3 decisions of the Supreme Court. I'll try and argue
Yes.
that the territorial jurisdiction in a Section 9 proceeding is not the deciding factor. It is the seat and the venue. If the seat is not mentioned, then the venue. And my lord, if the clause, the governing clause, my lord, the dispute resolution clause, if it states, if it refers to only venue, and if it refers to courts in Calcutta, then the court of principal civil jurisdiction is the court which is meant under 21E. But may I first start my submissions by referring to the decision in BBR India Private Limited versus SP Singla. This is 2023, Volume 1, Supreme Court Cases 693. Minute. That kindly pardon me, I'll have to refer to a few paragraphs here, because that is where, my lord, this is the one judgment which I'll refer to in extenso, my lord, because it has laid down the proposition. It has followed, my lord, 2 decisions of the Supreme Court, BGA Soma being, my lord, the first decision, which is considered Balco and then rendered the findings. Kindly take a paragraph 11 to begin with. So this is internal page 10, paragraph 11. The ratio is laid down here, my lord, but briefly the facts. Paragraph 11. The petition filed by the respondent under Section 9 of the Act before the Additional District Judge Panchkula was dismissed. We audited this on the ground of lack of territorial jurisdiction, inter alia recording that the jurisdiction to entertain the application vests solely with the Delhi High Court, where a prior petition under Section 34 had been filed and was pending. The petition under Section 9, being a subsequent petition, would be barred under Section 42 of the Act. My Lord, kindly take up the discussion, and thereafter, my Lord, paragraph 12. However, this order has been set aside by the High Court of Punjab and Haryana, vide order dated October 14, 2019, with the finding that the courts in Delhi do not have jurisdiction to entertain the objections under Section 34 of the Act. To this effect, the High Court of Punjab and Haryana has recorded that the agreement between the parties was silent as to the seat of the arbitration proceedings. And the second arbitrator, Mr. Justice, vide his first order had not determined Delhi to be the seat of arbitration. Relying on the decision of this court in State of West Bengal versus Associated Contractors, the High Court held that the courts at Panchkula had jurisdiction to deal with the case. Review petition filed by the appellant was dismissed. Over the page, these orders passed by the court have been assailed before us by the appellant. That's the premise, my lord, of the appeal being considered. Paragraph 14, my lord, Section 21E is quoted. Defines court along with Section 20, which is the place of arbitration. Court, my lord, may I only read this part? Court means in the case of an arbitration other than an international commercial arbitration, the principal civil court of original jurisdiction in a district, and includes the High Court in exercise of its ordinary original civil jurisdiction, having jurisdiction to decide the questions forming the subject matter of arbitration if the same had been the subject matter of a suit, but does not include any civil court of grade inferior to such principal civil court or any court of small causes. Then place of arbitration is quoted, jurisdiction, Section 42 is quoted. Then paragraph 15 onwards, Lord, kindly permit me to read this. Interpretation of the term court as defined in clause E to subsection 1 of section 2 of the Act had come up for consideration before the constitutional bench of 5 judges in Balco, which decision had examined the distinction between jurisdictional seat and venue in the context of international arbitration to hold that the expression seat of arbitration is the center of gravity in an arbitration. However, this does not mean that all arbitration proceedings must take place at the seat. The arbitrators at times hold meetings at a more convenient location. Regarding the expression court, it was observed that 2.2 of the Act does not make Part 1 applicable to arbitration seated outside India. The expressions used in 2.2 of the Act do not permit an interpretation to hold that Part 1 would also apply to arbitrations held outside the territory of India. Paragraph 16, my lord. Noticing the above interpretation, a 3-judge bench of this court in BGA Soma had observed that the expression subject to arbitration used in clause E to subsection 1 of section 2 of the Act cannot be confused with the subject matter of the suit. The term subject matter of the suit in the said provision is confined to Part 1. The purpose of the clause is to identify courts having supervisory control over the judicial proceedings. Hence, the clause refers to a court which would be essentially a court of the seat of the arbitration process. Accordingly, clause E of subsection 1 of section 2 has to be construed keeping in mind provisions of section 20 of the Act, which are in fact determinative and relevant when we decide the question of seat of an arbitration. The interpretation recognizes the principle of party autonomy, which is the edifice of arbitration. In other words, the term court as defined in E to subsection 1 of section 2, which refers to the subject matter of arbitration, is not necessarily used as finally determinative of the court's territorial jurisdiction to entertain the proceedings under the Act. In BGA Soma, this court observed that any other construction of the provisions would render section 20 of the Act nugatory. In view of the court, the legislature had given jurisdiction to 2 courts, the court which should have jurisdiction where the cause of action is located and the court where the arbitration takes place. This is necessary as on some occasions, the agreement may provide the seat of arbitration that would be neutral to both the parties. The courts where the arbitration takes place would be required to exercise supervisory control over the arbitral process. The seat of arbitration need not be the place where any cause of action has arisen, in the sense that the seat of arbitration may be different from the place where obligations are or had to be performed under the contract. In such circumstances, both the courts would have jurisdiction, that is, the court within whose jurisdiction the subject matter of the suit is situated, and the courts within whose jurisdiction the dispute resolution forum, that is where the arbitral tribunal is located. Turning to Section 20 of the Act, subsection 1 in clear terms states that the parties can agree on the place of arbitration. The word free has been used to emphasize the autonomy and flexibility that the parties enjoy to agree on a place of arbitration which is unrestricted and need not be confined to the place where the subject matter of the suit is situated. Subsection 1 of Section 20 gives primacy to the agreement of the parties by which they are entitled to fix and specify the seat of arbitration, which then, by operation of law, determines the jurisdictional court that will, in the said case, exercise territorial jurisdiction. Subsection 2 comes into picture only when the parties have not agreed on the place of arbitration as the seat. In terms of subsection 2 of Section 20 of the arbitral tribunal determines the place of arbitration. The arbitral tribunal, while doing so, can take into regard the circumstances of the case, including the convenience of the parties. Subsection 3 of Section 20 of the Act enables the arbitral tribunal, unless the parties have agreed to the contrary, to meet at any place to conduct hearing at a place of convenience in matters such as consultation amongst its members for the recording of witness, experts, or hearing parties, inspection of documents, goods, or property. Relying upon the constitutional decision in Balco, in BGS Soma, it has been held that subsection 3 of Section 20 refers to venue, whereas the place mentioned in subsection 1 of subsection 2, subsection 1 and subsection 2 refers to jurisdictional seat. To explain the difference, in Balco, a case relating to international arbitration, reference was made to several judgments, albeit the judgment in Sashua was extensively quoted to observe that an agreement as to the seat of arbitration draws in the law of the country as the curial law and is analogous to the exclusive jurisdiction clause. The parties have agreed to the seat must challenge an interim or final award only in the courts of the place designated as seat of arbitration. In other words, the choice of seat of arbitration must be the choice of a forum or court for seeking remedies, seeking to attack the award. The aforesaid principles relating to international arbitration have been applied to domestic arbitrations. In this regard, we may refer to paragraph 38 of BGS Soma, which reads as under. A reading of these paragraphs of Balco would show that the parties have selected the seat of arbitration in their agreement, which selection would then amount to an exclusive jurisdiction clause, as the parties have now indicated that the courts at the seat would alone have jurisdiction to entertain challenges against the arbitral award which have been made at the seat. The example given in para 96 buttresses this proposition and is supported by the previous and subsequent paragraphs pointed out herein above. The Balco judgment, when read as a whole, applies the concept of seat as laid down by the English judgments, and which is in Section 20 of the Arbitration Act 1996, by harmoniously construing Section 20 with 21E so as to broaden the definition of court and bring within its ken courts of the seat of the arbitration. The court in BGS Soma then proceeded to examine the contention whether para 96 of Balco, which speaks of concurrent jurisdiction of courts, that is the jurisdiction of courts where the cause of action has arisen wholly or partly, and the courts within the jurisdiction in which the dispute resolution forum arbitration is located, to observe and elucidate the legal position. BGS Soma, it's quoted para 40. Para 96 of Balco in several parts. First and foremost, 21E, which is the definition of court under the Arbitration Act 1996, was referred to and was construed keeping in view the provisions of Section 20 of the Act, which give recognition to party autonomy in choosing the seat of the arbitration proceedings. Secondly, the court went on to state in two places in the said paragraph that the jurisdiction is given to two sets of courts, namely, those courts which have jurisdiction where the cause of action is located, and those courts where the arbitration takes place. However, when it comes to providing a neutral place as seat of the arbitration proceeding, the example given in the 5-judge bench made it clear that appeals under Section 37 of the Act against interim orders passed under Section 17 would lie only to the courts of the seat, which is in Delhi, for example, in that example, which are courts having supervisory control of jurisdiction over the arbitration proceedings. The example goes on to state that this would be irrespective of the fact that the obligations to be performed under the contract, that is the cause of action, may arise in part either in Mumbai or Kolkata. The fact that the arbitration is to take place, kindly mark this, my lord, the fact that the arbitration is to take place in Delhi is of importance. However, the next sentence in the said paragraph reiterates the concurrent jurisdiction of both the courts. BGS Soma extensively refers to the judgment of this court in Indus Mobile, which decision refers to the legislative history of 21E and Section 20 of the Act and the recommendations of the 246th Law Commission Report 2014. These recommendations, it is observed, were not implemented in consonance with the decision in Balco, which in no uncertain terms refers to place as the jurisdictional seat for the purpose of Clause E to subsection 2 of Section 2 of the Act. This judgment has been subsequently followed in Brahmani River Pellets Limited. It may, however, be noted that Clause E of subsection 1, Section 2 was amended by inserting subclause 2 with the specific objective to solve problems of conflict of jurisdiction that would arise in cases where interim measures are sought in India, in cases where arbitration seated outside India. In the context of domestic arbitration, it must be held that once the seat of arbitration has been fixed, then the courts in the said location alone will have exclusive jurisdiction to exercise supervisory powers over the arbitration. The courts at other locations will not have jurisdiction, including the courts where the cause of action has arisen. As observed above, it was held in BGS Soma and Indus Mobile. The moment the parties agree, by agreement designate the seat, it becomes akin to exclusive jurisdictional clause. It would then vest the courts at the seat with exclusive jurisdiction to regulate arbitration proceeding arising out of the agreement between the parties. But over the page, paragraph 24. The court in BGS Soma has also dealt with a situation where the parties have not agreed on or have not fixed the jurisdictional seat of arbitration and has laid down the following test to determine the seat of arbitration, which would determine the location of the court that would exercise supervisory jurisdiction. The test is simple and it reads as under. It will thus be seen that wherever there is an express designation of a venue and no designation of any alternative place as the seat, combined with a supranational body of rules governing the arbitration and no other significant contrary indicia, the inexorable conclusion is that the stated venue is actually the jurisdictional seat of the arbitration proceeding. For formulating the test, reference was made to several Indian and foreign judgments to emphasize that there were parties had failed to choose the jurisdictional seat which would be governing the arbitration proceedings. The proceedings must be considered at any rate prima facie as being governed and subject to jurisdiction of the court where the arbitration is being held, on the ground that the said court is most likely to be connected with the proceedings. Accordingly, in BGS Soma, the law as applicable, where the parties by agreement have not fixed the jurisdictional seat, is crystallized as under. Paragraph 82 is quoted. On a conspectus of the aforesaid judgments, it may be concluded that whenever there is a designation of a place of arbitration in an arbitration clause as being venue of the arbitration proceedings, the expression arbitration proceeding would make it clear that the venue is really the seat of the arbitration proceeding. In the aforesaid expression, it does not include just one or more individual or particular hearing, but the arbitration proceedings as a whole, including the making of an award at that place. This language has to be contrasted with the language such as tribunals are to meet or to have witness, experts or parties, where only hearings are to take place in the venue, which may lead to the conclusion, other things being equal, that the venue is so stated is not the seat of the arbitral proceedings, but only a convenient place of meeting. Further, the fact that the arbitral proceedings shall be held at a particular venue would also indicate that the parties intended to anchor the arbitration proceedings to a particular place, signifying thereby that that place is the seat of arbitral proceedings. This, coupled with there being no other significant contrary indicia that the stated venue is merely a venue and not the seat of the arbitral proceedings, would then conclusively show that such a clause designates a seat of the arbitral proceedings in an international context. If a supranational body of rules is to govern the arbitration, this would further be an indicia that the venue, so stated, would be the seat of the arbitral proceedings. In a national context, it would be replaced by the Arbitration Act 1996 as applying to the stated venue, which then becomes the seat for the purpose of arbitration. Now, my lord, paragraph 27. When we turn to the facts of the case, so in the facts, then it was decided, but this is the ratio which is laid down, which I'm placing reliance on. Thereafter, the facts are discussed. But may I quickly, before I refer to Arif Azim, may I quickly indicate BGS Soma in a paragraph has dealt with section 9. Proceeding under section 9, my lord. One more. My lord, since it is extensively quoted in BBR, I'll not be referring to, my lord, most of the provisions, only one paragraph. The premise laid down in BGS Soma is, my lord, already quoted in BBR. It says, if, my lord, there's a seat which is agreed to by and between the parties, then it will have exclusive jurisdiction. And, my lord, in case a seat is not designated, then what happens is, my lord, indicated in paragraph 59, internal page 55.
Paragraph?
The paragraph 59 at internal page 55 of the judgment, my lord. The last line is what I'm referring to, my lord. Again, an application. So, my lord, there was a discussion under for section 42, how it would guide. But this part deals with section 9. Again, in an application under section 9, the last line, my lord, on the page, paragraph 59. An application under section 9 of the Arbitration Act 1996 may be preferred before a court in which part cause of action arises in a case, my lord, kindly mark this, in a case where the parties have not agreed on the seat of arbitration, and before such seat may have been determined on the facts of a particular case by the arbitral tribunal under section 22 of the Arbitration Conciliation Act. In both these situations, the earliest application having been made to a court in which a part cause of action arises would then be the exclusive court. So this is, my lord, when it is not decided. If it is decided, nothing else, my lord, is to be taken into consideration if there's a seat or venue. And if there's only venue and no seat, I'll refer to the third judgment, which says how to apply Sashua principles to this situation, where, my lord, the venue will be construed as the seat. Because here, my lord, is the venue which is referred to. My lord, test for determination of seat, paragraph 60. The Sashua principles are referred to. My lord, kindly don't look into this because this has been developed in the next judgment. I'll refer to that.
Yes, just hang on.
My lord.
We prefer before a court in which My lord, may I read out, my lord, paragraph 60 also. 60 is, my lord, the judgments of the English courts have been examined
have examined the concept of the juridical seat of arbitral proceedings and have laid down several important tests in order to determine whether the seat of the arbitral proceeding has in fact been indicated in the agreement between the parties. Lord Justice Cook's Milord Shashua principle is quoted here. London arbitration is a well-known phenomena which is often chosen by foreign nationals with a different law, such as the law of New York governing the substantive rights of the parties. This is because of the legislative framework and supervisory power of the courts here, which many parties are keen to adopt. When therefore there's an express designation of the arbitration venue as London and no designation of any alternative place as the seat, combined with a supranational body of rules governing the arbitration and no other significant contrary indicia, the inexorable conclusion is, to my mind, that London is the juridical seat and English law is the curial law. In my judgment, it is clear that either London has been designated by the parties to the arbitration agreement as the seat of the arbitration, or having regard to the parties' agreement and all the relevant circumstances, it is the seat to be determined in accordance with the final fallback provision, section 3 of the Arbitration Act. It will thus be seen that wherever there is an express designation of venue and no designation of any alternative place as seat, combined with supranational body of rules governing the arbitration and no other significant contrary indicia, the inexorable conclusion is that the stated venue is actually the juridical seat of the arbitration proceeding. But here in this judgment may also indicate one paragraph, which is paragraph 82 at internal page 68. Paragraph 82, I'm not reading this out, This was quoted in BBR. I've read from there. I'm only indicating this is the paragraph, Venue and seat has been explained. In this decision, in paragraphs 91 and 94, the three judges bench decision of the Supreme Court in Hardy Exploration has been distinguished and held per incurium. Paragraph 91 and 92, the only reason being that in Hardy Exploration, the Honorable Supreme Court has failed to take note of the Shashua principle. Kindly see paragraph 91. Three judges bench in Hardy Exploration failed to apply the Shashua principle to the arbitration clause in question. Paragraph 91, page 73. Page 73. Had the Shashua principle been applied, the answer would have been that Kuala Lumpur, which is stated to be the venue of the arbitration proceeding, being governed by the ancestral model law, would be governed by supranational set of rules, and there being no other contrary indicator, it would be clear that Kuala Lumpur would therefore be the juridical seat. And paragraph 94, which is at page 75, where it is held, the decision in Hardy is therefore contrary to the five judges bench in Balco, in that it failed to apply the Shashua principle to the arbitration clause in question. Now, Milord, may I refer to Arif Azim, it's a 2024 decision. Only a few paragraphs here, Milord. Only for the purpose that if the venue but only for the purpose that if it is only venue which is stated, but since in the facts of our case, Milord, it's only venue, I'll show the arbitration clause.
Paragraph.
Now, the issues are at paragraph 20, page 22. Paragraph 20 at page 22 minute. The analysis starts from paragraph 21. The tests are the only parameters which I am going to refer to. Kindly take up paragraph 41 at page 57. Paragraph 41 at page 57. There are two tests which are laid down for determining the venue and seat. Page 57, my lord. Criterion or test for determination of seat of the arbitration. Conflict of venue versus seat of arbitration. First test is laid down after paragraph 41. Closest connection test. Place of arbitration to be ascertained by the law governing the arbitration agreement and not the place of arbitration. I am referring to the second principle, my lord, which is at page 70, paragraph 50. The Sashua principle, venue to be construed as seat. Page 70, my lord. Paragraph 15, Roger Sashua, the Queen's Bench Division Commercial Court of the England and Wales High Court held that there is an express designation. When there is an express designation of the arbitration venue as London and no other designation of any alternative place as the seat, combined with the supranational body of rules governing the arbitration and no other significant contrary indicia, the inexorable conclusion would be that such venue in fact is the jurisdiction seat, is a juridical seat. It is observed that often in arbitration agreements it is much more likely that the law of the arbitration agreement will coincide with the curial law, and thus any express stipulation of the curial law would aid in the determination of the juridical seat. Relevant observations are quoted, my lord. I'll request your lordship, my lord, to take up paragraph 53. I'm not troubling your lordship with the details because there's a summation also. Paragraph 53, may I refer to at page 78, my lord. The tests set out in BGS SOMA are encapsulated here. 3-condition test as to when venue can be construed as seat of arbitration. Conditions are: 1, the arbitration agreement or clause should have in question should designate or mention only one place. Such place must have anchored to the arbitral proceedings, that is, the arbitral proceedings must have been fixed to that place alone without any scope of change. So no seat is mentioned.
Ultimately, parties agree that Kolkata is the seat. Kolkata could otherwise choose এটা কি বলেছে পড়তে হবে। Yes.
The third condition is there must be no other significant contrary indicia to show that the place designated is merely the venue and not the seat. So if there are two places mentioned, or my lord, if there's a...
So you are arguing parties by agreement can confer jurisdiction on a court.
In an arbitration proceeding.
In an arbitration.
And that is the difference, my lord, with the civil jurisdiction. In a civil proceeding, it cannot be done. But today, if it's a suit, then in a suit, this could not have been done. They could not have had a, my lord, exclusive jurisdiction, and that the guiding factor would be different there than in a Section 9 proceeding. And that is what is held in BBR by referring to BGS.
What is the clause here in this case? In your case?
I'll indicate. The clause here refers to
page 40, page 48.
It's at page 48. May I read it out, my lord? All proceedings shall be conducted, it's page 48, conducted in English, in a daily transcript in English shall be prepared. The venue of the arbitration shall be Kolkata, India. So the principal court of civil jurisdiction would be City Civil Court. The order of such arbitral tribunal shall be final binding on this. So there's no other place referred to here. It's stated venue of the arbitration shall be Kolkata, India. Hence Arif Azim. Hence the social principles. No contrary indicia here. And the court in BBR, my lord, has gone a step further to indicate that in such a situation, both the courts will have concurrent jurisdiction. So the contention of my learned friends that the territorial jurisdiction is missing, in my very respectful submission, cannot be sustained. Now, my lord, may I indicate those two paragraphs of Arif Azim after referring to the socio principle and, my lord, encapsulating BGS Soma's principles in paragraph 53. The conclusion is at paragraph 71 at page 92. My lord, kindly take up Roman 4 of paragraph 71, my lord, at page 92. From the above exposition of law, the following position of law emerges. Roman 4. The moment seat is determined, it would be akin to an exclusive jurisdiction clause whereby only the jurisdictional courts of that seat alone will have the jurisdiction to regulate the arbitral proceedings.
Is a Section 9 proceeding regulation of the arbitration proceedings?
Yes, but my humble submission is that is what is also recorded in BGS Soma, that in case it's a Section 9 proceeding, how is it to be interpreted if there is no seat which is designated? If there's a seat designated, Section 9 is clear. That's what BGS Soma says.
What happens if there is, let us say, no seat designated at the inception? Section 9 is filed in a court which qualifies under Section 2(1)(e) of the Arbitration Act. Subsequently, a seat of arbitration is agreed upon by the parties. And necessity arises, need arises for another application under Section 9 to be filed. This seat of arbitration agreed upon by the parties is Chennai. The earlier Section 9 application was filed in Kolkata. The second application will be filed where?
There is a judgment to that effect.
Chennai.
First, my lord, it is stated that there can't be, my lord, a subsequent change in the seat. Seat is to be determined once.
There is no change.
If there is no change, my lord, then once it is decided that that is the court, there will be an option for the parties, my lord. The parties can then go with the, my lord, territorial jurisdiction, court having territorial jurisdiction, because to begin with, there was no seat which was agreed upon by the parties.
So in that case, Section 42 will go out of the window.
Section 42 will be guided. My lord, there was a judgment I had read, my lord, where the issue was between Ahmedabad and, my lord, Bombay. Very similar. My lord, there were two applications which were filed, my lord, and then it was decided. I think it was in this mobile, my lord, where this point was taken, and my lord, it was paused, and then it was resent to the Ahmedabad courts, if I'm not wrong, my lord. That was what was the finding in this mobile, my lord. Very similar, but my lord, there the seat was not determined later. In BGS Soma, it is held, my lord, that if the seat is not determined, then there's an option of the territorial court having jurisdiction. Then the concept of part cause of action also comes in, and the parties are at liberty to institute the proceeding under Section 9 in any of these courts. That's what is reiterated in BBR, my lord.
Where is that portion in BBM? Show us once more.
My lord.
BBR or
My lord,
BGM?
BBM has, my lord, an extensive discussion on Section
BBM?
20.
BBM or BBR?
My lord, BGS.
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 Yes. Which paragraph?
My lord, this is paragraph 59. Because the previous discussion was, my lord, with regard to Section 20 being the place of arbitration, 21E and 42, which is extensively discussed. By placing reference on Balco's decision, and the premise, my lord, is set out at paragraph 32 at page 35.
No, read 59. Slowly read
59.
59. 59 talks of a situation where no seat is agreed upon.
My lord.
Section 9 is filed in a court where cause of action has arisen. Subsequent seat may be agreed upon, but 42 will apply.
Yes, my lord. And that, my lord, the premise is that if a seat is designated to begin with, then this has not to be this would not be required to be looked into. So in my case, my lord, in the present facts, the seat is designated. And that is why, my lord, I'll refer to that last concluding paragraph of Arif Azim, where, my lord, the moment venue is indicated with no contrary indicia, no other place referred to, but that would be considered as seat. And once there is a seat, the court inherently has jurisdiction. And it's a choice of the parties. The parties have to then go before the court of principal civil jurisdiction, which is the city civil court. And that is reiterated, my lord, in BBR's judgment. By quoting extensively from BGS. And, my lord, referring to the Sashua principle.
Then why shouldn't all courts in Calcutta have jurisdiction?
The principal court, my lord,
Why you are not relying on 21E?
I am, my lord.
21E is being jettisoned.
No, my lord, I am. My lord, that is what, my lord, in the decision of BBR, that is what the Supreme Court has said. The interpretation is, my lord, always with Section 20, 21E read in consonance with Section 20. Section 20 being the place of arbitration, drawing its reference from the concept of venue and seat. And what happens if there is no venue designated? I'm sorry, if there is no seat designated, and if only venue is referred to. That was the confusion which is thereafter clarified in Arif Azim, that if there's nothing contrary, then this venue will tantamount to seat. In my case, in the present facts, the seat, therefore, is Calcutta. If the seat is Calcutta, then Section 9 can be, my lord, moved before a court where, my lord, there is no subject matter, doesn't have territorial jurisdiction, but can be entertained and decided by the court. Kindly take up, my lord, the last paragraph of Arif Azim. I'll just indicate, my lord, the 4 points which I'm placing reference on.
Yes.
This I'm submitting, my lord, because my learned friend has also given me those 2 judgments which my learned friend is going to rely on. One of them, I'll wait for the reply, but one of them, you are referring to those 2, right? Yes. One of them, my lord, is Order 7, Rule 11 for an exclusive jurisdiction clause in a suit proceeding. So the court has held, while deciding an Order 7, Rule 11, that if there's an exclusive jurisdictional clause in a suit, that would not mean that particular court has jurisdiction, which is, my lord, the facts, the law. And this is what, my lord, BBR says, that in arbitration matters, that would not be the guiding factor. In arbitration, that's the subtle distinction between, my lord, a suit court or matter before the suit court and an arbitration proceeding.
So in arbitral matters, parties by agreement can confer jurisdiction on a court,
Party autonomy.
contrary to all settled principles of law.
This is what, my lord,
No,
is,
what can you do?
my lord.
We have to read it carefully again. If the Supreme Court has said so, we are bound by it. There's no question about it.
My lord, this is the reason, my lord, I was trying to canvass this submission, that this premise of an arbitration is different from, my lord, a civil
What
proceeding.
else? What else?
Paragraph 71 of Arif Azim.
Yes. Yes, subparagraph 4 you have shown us.
Subparagraph 4, my lord. 5 is the closest connection test. 6. The more appropriate criterion for determining the seat of arbitration in view of subsequent decisions of the court is that wherein an arbitration agreement there's an express designation of a place of arbitration anchoring the arbitral proceedings
These
to
are
such
not
place.
relevant, mister, because only thing that is relevant is where the Supreme Court says that the courts at the place of seat
My lord.
of arbitration shall have exclusive jurisdiction.
That's BBR.
Roman subparagraph 4 also.
Also 4, my lord. Also
Subparagraph 4.
6 and 7 also. Because 6 and
those
7
are tests to determine the seat.
Indeed.
We are not on that.
Lordship.
Seat is, let us say you are right, seat is Kolkata.
My lord.
We are looking for the proposition that then that becomes the exclusive
jurisdiction clause. And that's what is reiterated in Arif Azim following, my lord, BGS Soma and BBR.
Anything else?
These are my submissions.
Yes, sir.
I would like two judgments. Before that, my lord, can you take the my lord, before that, my lord, can you take their section 9 application? My lord? How they attract the jurisdiction of the court?
However they do it, if his argument is correct,
No,
then
my argument is according to me.
nothing is important excepting seat,
Then, my lord, can you take the
venue, Kolkata, seat
Kolkata.
not named, therefore venue is the seat,
it may be
and
district
then
court
only
also, my lord.
Kolkata.
Kolkata, the district court, Halipur is in Kolkata, Bharashwat, Barakpur. My lord, I am not on that. My lord, can you take the definition of the court? May I read one?
দেখে কি হবে definition? Read.
No, my lord, if I am not, my lord knows that I am just distinguishing.
Answer his point. Nothing is important.
That is important. Then, my lord, can you take the judgment of the Supreme Court, my lord? It is an unreported judgment or reported somewhere else. I don't know, my lord, but can you take the paragraph 2? What was the clause?
Yours is also a development agreement.
Yes, my
Yours?
lord. It's a lease agreement, my lord.
Lease.
Lease agreement. Section 9 filed, my lord, Muzaffarpur court, my lords. Interim was granted, my lord. The court says, Section 11 filed in this court, my lord. This court appointed the arbitrator, my lords. And the review application was filed. Review application was dismissed. Went to the Supreme Court. Supreme Court says no. The immovable property is the outside jurisdictions. And the application Section 9 filed there. How the Calcutta High Court jurisdiction, my lords. My lord, kindly take, my lord. Paragraph 2, what was the clause? Another paragraph 47. This court appointed the arbitrator, my lord. Again, the Supreme Court. My lord, can you take
47.
47, my lord.
Yes.
It is well settled that when two court or more court have the jurisdiction to adjudicate the dispute arising out of the arbitration agreement, the party might, by agreement, decide to refer all dispute to any one court, to the exclusion of any all other court, which might otherwise have jurisdiction. to decide the dispute. The party cannot, however, by concept, confer the jurisdiction on a court which is inherently lack of jurisdiction, as argued by Mr. Singh.
Karun, so sure. But করে দিয়েছে একটা সেন্টেন্স আমি পড়েছি correct correct কোথায় যেন ওটা দেখতে page 16 yes
Then my lord said that the order was passed by this court was set aside, and courts appointed the neutral arbitrator, Supreme Court, my lord. The seat of arbitration was same clause was acting to same clause, my lord. In that agreement was also.
problem is this is a two-judge bench decision.
My lords.
The decisions cited by Mr. Bagh are all, I think, three-judge bench.
3 judges, my lord.
And another problem, as my brother pointed out, come to page 16.
16.
Reliance has been placed on hardy exploration.
That was declared per inquiry, my lord. That was distinguished, my lord. Not Hardy was not recorded, my lord. They follow the Hardy, my lord. The Supreme Court says that no, the Kolkata, but the immovable property is the outside jurisdiction of that court. The Calcutta court don't have a jurisdiction, my lords.
Yes.
Only one, my lord. Whatever the judgment by learned friend Rai, my lord, none of judgment according to me dealt with the situation where the property is situated outside, immovable property.
You're right there. There you're right.
There is all judgment, well, distributorship agreements or international arbitration, all the transaction commercial touches, which is not dealt with the immovable property, my lords. Now the situation is, my lord, this is the immovable property. My lord, the 15, 16, my lord, CPC will be guide. My lord. Section 2(1)(e) courts, my lord, the subject matter which has been subject matter of the
No, according to Mr. Bagh, nothing will guide.
My lord, my respect, Mr. Bagh may be right, my lord, but my respect was.
No, what can Mr. Bagh do if the Supreme Court has said
my lord,
so?
but the Supreme Court, my lord, what I rely, my lord.
Very well, let us consider. Let us
I'll
consider.
quickly distinguish, my lord, what my learned friend, and in one line, my lord. But the decision which my learned friend has just cited, paragraph 48, there's an observation. Neither of the parties to the agreement construed the arbitration clause to be designated. Arbitration clause to designate Kolkata as the seat of arbitration. So the seat was not Calcutta, and that is, my lord, was taken into consideration by the court. The other matter, my lord, the other judgment which my learned friend has referred to, Alpha. This is Ravi Ranjan. paragraph 48.
Yes, we have followed.
And the other judgment, my lord, alpha residence is not really relevant. My lord, there, my lord, a suit was filed, order 7, rule 11 was being moved, and this point was taken.
No, he has not relied on that.
No, my lord, I have not relied.
As
This
per
is
your own
related to the CPC, my lord, I have not. My lord,
So we have only till now, and we are considering only the question of jurisdiction,
Right.
not on merits.
Not on merits.
If we hold that, yes, you are right, as far as jurisdiction is concerned,
Right.
then we'll consider merits, whether on merits he can assail
Lordship.
the order of whatever you have obtained from the.
Right. Because section 9 is not under challenge. The order of section 9 is not under challenge.
What is under challenge?
There's a application which they filed
711. No.
in the nature, my lord, of an order 7 rule 11 saying, my
Oh,
lord, challenging
so only this point.
only this point. My lord.
Okay.
Only this point.
All right.
That's the reason.
All right. Okay, Gaurav, we'll take a little time. You can understand.
Definitely.
Because we'll have to read all these
Lordship.
voluminous judgments.
I'm sorry, my lord, for troubling your lordship.
No. What
It's a
can
very
you do?
interesting point, my lord.
Interesting point, no doubt. We just wish we had fewer cases so that we could concentrate. These are interesting, actually. But you appreciate, no? It unsettles a few things which have been long established.
That's
my lord, may I come back, my lord, one judgment, there is, my lord, last night I have searched, my lord, but I could not find, there is a judgment of Justice Sanjeev Banerjee, my lord,
I'm carrying that.
dealing with that's all judgment cited by
No, my lord. Those
There's
that's,
except
I'll indicate that judgment. I have that.
in the mobile.
Just tell him if it's the same one he's thinking about.
I'll immediately indicate.
Hinduja Leylands,
I'll just tell.
including all the judgment in
No, my
territory.
lord, it was not the recent judgments which I referred to, my lord, that those were not considered.
Indus Mobile was considered and distinguished. My
No, but these couldn't have been
Couldn't
because
be, my lord,
lord. Arif Azam was not there at that point of time, my lord. Arif Azam was not there. Arif Azam was not there at that point of time.
I'll give that decision to my learned friend. I have that, my lord, but that's not applicable. That's the reason that I didn't bring it. What are applicable now? The 48 decisions to less.
No.
give us that judgment on Tuesday.
I will, my lord.
On Tuesday.
I will. And I'll also indicate that that is, my lord, that did not take up, my lord, take into consideration, could not have, my lord, the subsequent decisions. These are the ones, my lord, which guide the subject. My lord.
We have heard. Now, learned advocate for the appellant wishes to rely upon one more decision. Stop. List this matter once again on Mongolbar, Tuesday, under the heading to be mentioned.
I'm grateful.
Just hand up that. That's all.
Deeply pleasure. We will.
Then we will post it for orders three weeks hence or something.
Very deeply obliged, my lord, for the
I'm
patient hearing. Very deeply obliged.
My appeal.
Well done for the respondent number 1.
Can 1 is a stay application. That we'll file a supplementary affidavit to which they had filed their opposition. They've served upon us the opposition. From an award.
What's can 2?
Can 2 was a restoration application which was allowed by my lord.
Can 3?
Can 3 was condonation of delay in filing the restoration application. That was also allowed. And but there were costs imposed upon me. We have paid the cost. Everything has been done.
Okay, let us go through the order.
Yes. The extra.
Yes. 18 award. তারপর 18 judgment award. What is the date of the award?
The date of the award is the 11th May 2012 minute.
কি করেছি দুবার
Not supposed to say this if this is no, it's the award of the
এটা তো বাংলাদেশি কথা অ্যাওয়ার্ড চ্যালেঞ্জ করে আর ওই ব্যাংকারি এটা ফেরত দিচ্ছিল না Correct. Yes.
In the award minute, the only challenge which they had made out was with regards to non-grant of interest on delayed payment. The Section 34 court modified the award by granting them interest. In my most respectful submission, the act of modifying the award in itself was bad, and we're challenging that we came up before my lords. But interest on delayed payment, as the if my lord considers page 43 of the award and interest was not granted because the claim had on that day not fructified because these were all on account advance payment. But if my lord sees the terms of the contract,
A sum of money was awarded.
Yes, ma'am.
that will kindly
40 lakhs.
will kindly have a look.
42 lakhs. Your counterclaim 2 lakhs. Net amount 40 lakhs.
Will kindly have a look at the challenge with page 43 minute of the award once.
Statutorily, they were
No,
entitled to.
will kindly have a look at page 43 once of the award minute. The contention was with page 43, the claimant has made a claim of 1 crore 64 lakhs in odd as interest calculated up to 30th September 2006 on alleged delayed payment to them as a small scale unit. It was not interest
Ma'am,
on.
we'll not look into all that.
Very good.
Rightly or wrongly, a sum has been awarded.
Yes,
You
40
have not
lakhs.
challenged that.
I have not challenged.
Correct.
40 lakhs in odd, I have not challenged.
Rightly or wrongly, a sum has been awarded. He was entitled to interest under section 31(7). Full stop.
We'll kindly have a look at the interest quantum then. The amount which has been granted, 79, page 79.
That arithmetical calculation we can't do.
But compounded annually. We'll kindly have a look at page 69, page 79. 40 lakhs we had not challenged. Then section 34 court modifies it.
There is hardly any modification. Section 34 code clarifies that they are entitled to interest because the statute says so.
So the section 18, the interest on delayed payment under the MSME Act,
What you wanted to show us?
page 79. The grant is compounded annually. In 2012, the award was passed.
Correct. Yes, madam.
But first of all, the NIT, the contract was purchase order was executed in the year 2005. At that point in time, the certificates which my learned friend's client had were only with regards to we'll see at page 46. It has been recorded that the claimant submitted a copy of their permanent registration as a small scale unit from the director of 1980 from the Director of Cottage and Small Scale Industries, governing the manufacturing processing activity of synthetic resin and fiber reinforced plastic molding. The claimant further submitted by their letter dated 10th May 2011 to acknowledgement of entrepreneurs memorandum part 2, both dated 30th August 2007 in the name of Ruya Chemicals, and then considering the fact that these do not bring in the purview of the erection and not molding. Therefore, this was not granted to them. As regards MSME, but even considering 31(7), if there was an interest amount quantum which was to be paid to them, but it would not have been 18% compounded annually.
What should it be? You tell us.
Look, the statute says, unless otherwise agreed by the parties, wherein insofar as the arbitral award is for payment of money, the arbitral tribunal may include in the sum for the award is made interest at such rate as it deems fit reasonable on the whole or any part of the money for the whole or any part of the period between the date on which the cause of action arose and the date on which the award is made. The sum directed to be paid by the arbitral tribunal shall, unless the award otherwise direct, carry interest at the rate of 2% higher than the current rate of interest.
That's post-amendment.
And that
That
even
is
if it,
post-amendment, madam. What are you reading? It was amended in 2016.
the statute here, what has been provided, the post
You are-
the expression current rate of interest shall have the same meaning as of
The award is of
Interest Act.
2012.
12.
yes, 2012.
What you just now read came in 2016.
Yes, that is true. Yes, I'm sorry, 2012 was the amended prior to amendment was
18%.
18%.
18%.
Yes.
My issue, I will join the issue later. Compounded annually with simple interest is no difficulty.
Are you agreeable to pay simple interest?
Even if that be so,
Can be finished off.
I'll take instruction and come back.
Better. You also take instruction. Otherwise, they will go up to Supreme
And
Court.
simple interest to the extent of award. Now what they are seeking is from 2012 to
Simple interest
2018.
for the same period that has been awarded. Not compounded annually, but simple.
If I say this, the award was of 2012. They preferred a challenge in 34. Had that been the contention, then we had made efforts to reconcile and we had made efforts to sit for settlement. Whatever be it, 2012 to 2018 simple interest is, if my learned friend is agreeable, I will have a word with my client and come back.
Yes. Hey, Yeshu.
There are 2 bank guarantees also, my lord.
I've taken instruction on that also.
That you have to release.
Finally release that.
No,
bank.
performance guarantee, the award itself has said that it's released.
Yes.
The other one I have not followed for liquidating damages.
The issue which is there is the bank guarantee were not extended. They were kept unrenewed. But they have lapsed. To my understanding and my client's instructions are such that we had proposed to them to come and collect the bank guarantee because they had any which ways they had expired.
So can we record that?
I will again, since the person who was instructing at that point in time in section
This is the
34,
problem with government companies. We are all
today morning that I have spoken
My
with them
client
on
is
this, they will
suffering,
come
my
back.
lord.
Because admittedly, the bank guarantees were not extended.
yes. You see, better advise your client to accept simple because compound is possibly not contemplated by law also.
I will take in.
So
I will also speak with my client.
this appeal is directed against an order dated May 8, 2018, passed by the additional district judge, first court, South 24 Parganas, Alipur, on an application under section 34 of the Arbitration and Conciliation Act, 1996, filed by the respondents herein. Stop. Paragraph. Disputes and differences having arisen between the appellant and the respondents in relation to a contract, comma, arbitration took place. Stop. The respondent company, bracket dekho, Ruia Chemicals Private Limited, was the claimant. Stop. The appellant, bracket Mrs. Bama Lorry Company Limited, was the respondent before the arbitrator, before the arbitral tribunal. Paragraph. The tribunal awarded a sum of approximately rupees 40 lakh to the claimant, to Ruia, after adjusting the amount of rupees 2 lakh, which was the amount of counterclaim made by Bamalori and which was allowed. Stop. The arbitrator also held that Ruia is entitled to get back the performance guarantee. Yes, performance guarantee. Stop. However, comma, the arbitrator did not award interest. Stop. Paragraph. To the extent that interest was not awarded and another bank guarantee was not released by the arbitrator, comma, Ruia filed the said Section 34 application challenging the award. Paragraph. The learned trial court awarded interest for the computation.
79 is the computation.
Awarded interest for the period 11/5/2012 to 11/3/2018 at the rate of 18% per annum, compounded annually. Huh? The learned trial court also held that Ruia is entitled to get back both the bank guarantees. Stop. Paragraph. Being aggrieved, comma, Bamalori has come up by way of this appeal under Section 37 of the 1996 Act. Paragraph. We have heard learned counsel for the parties at some length. Stop. Paragraph. We see that the learned trial court has awarded a sum of rupees 65,92, 426 on account of interest at the rate of 18% per annum, compounded annually on the award amount of rupees 40,42,148. Wait, right. Oh. But isn't the calculate for you the compounding actually? hidden from back calculation of the amount. Paragraph. Learned advocate for Bamalori says that awarding compound interest is not contemplated by law. Stop. We inquired of her whether or not Bamalori is agreeable to pay interest at simple rate for the aforesaid period in according at the rate contemplated at the rate mentioned in section 31(7) of the 1996 Act as it stood prior to its amendment in 2016. 2015. Stop. We have also requested learned advocate for RIA to obtain instruction as to whether or not her client is agreeable to accept simple interest at the rate of 18% for the period of time indicated by the learned trial court. Paragraph. We are not mentioning this, but that bank guarantee also bring instruction.
Yes, no, definitely.
List this matter once again on Tuesday. Tuesday date thou. Thursday date thou. Thursday date thou. Under the heading for orders.
That kindly mention the matter of bank guarantee.
No, I will.
আরেকটা একটা লাইন করে দিও তাহলে learned advocate for Bamalori shall also seek instruction as to why the bank guarantees that RIA had furnished have not yet been returned to RIA. তারপরে for orders করে দাও Mr. Banerjee, 12:15 the matter is fixed.
I can come back.
So will it be of any use? It's 12:12 now.
We can come back at 2.
Any other day, Milord, which is convenient to your
2 o'clock?
Yes, my lord.
Monday, if Milord, it is Milord convenient to your lordship's Monday, Tuesday.
No, it'll be there when it is.
Oh, Milord, I'm sorry, Milord, I have a matter.
That's all right.
But in this building, only when it's a fixed matter.
Then do it on Monday or Tuesday. Do it on Tuesday. 12:45 কোনটা 12:15 ম্যাটার কোনটা কেউ নেই তো
স্যার দুটো ম্যাটার দুটোর সময় ফিক্সড আছে তো বলছো এটা টাইম ফিক্স করে
But I'll wait for my turn, Milord, in case Milord the learned
in
and
case this is not taken up, just let us see. Call দেখি অন্য ছোটখাটো কিছু আছে কিনা কল করে যাও পাস ওভার না ও তো হয়ে গেছে সাহেবের হয়ে গেছে
Milord, Lordship, one prayer. If it is not taken up today and if it is taken up on Tuesday, will Lordship fix the time on Tuesday? Then my learned friend is also here.
Come back, it's where it is. It should definitely be taken up. Third item.
Tuesday. Grateful.
Mr. Kaur.
Since item 3 has been passed over, mine was item 4. I'm for the appellant.
We have called the matter, Mr. Das.
So this matter will go on.
But you don't want to do your matter today?
Waiting for 10:30 today.
But first of all, I want to take your lordship, Lord, through a list of dates because, Lord, I have prepared a list of dates. This has a checkered history. Therefore, I thought that I'll just quickly, Lord, face the list of dates that will, Lord.
Let us tell you very frankly, excepting the point of 12A,
Yes,
nothing has impressed us.
I will deal with the point of 12A first. So, Lord, and so far as Order 39, Rule 1 and 2, or Lord,
Hey, এটা দাও.
there are basically 3 points which were argued by actor. So, list of this copy. দুটো কপি দাও আর ওদের একটা কপি দাও বলে দিয়ে actually, Lord, 3 points.
As we have noted, Mr. Kaur, number 1,
Yes.
Order 39, Rules 1 and 2,
Yes.
no power to direct payment of occupational charge. One case has been cited. Second, suit and counter-suit are pending.
Yes.
From 1993, the appellants are in possession without paying a farthing. Every possibility of establishing adverse possession. Without eviction decree, no occupational charge should be directed to be paid.
Absolutely.
Number 3.
Yes.
Without a declaration that the appellants are in illegal occupation, the impugned order is not sustainable to decisions of the Supreme Court. Number 4. This 2022 SCC online final order, all those, in this case only.
Yes.
And then the 12A, your 12A has traveled up to the Supreme Court, so that chapter is over.
I'll show that, Lord. But before that, may I just, Lord, just for the purpose of placing the facts, may I just quickly, Lord, run through this list of dates, because this will give your Lordship an insight of the various proceedings that has been happening between the parties, including, Lord, the proceedings which have been initiated post filing of the suit for eviction.
1245 টা কোন ম্যাটারটা বলতো?
Lord, if your Lordship kindly looks at the dates, Lord, 15 December 1973, there was a lease of the suit property. Now, Lord, this was lease was for a commercial purpose, because, Lord, for manufacturing of ferroalloys. The lease itself, Lord, mentions that. Then, Lord, 30th November 1993, the lease expires by a flux of time. Then 1st March 2023, the state of West Bengal promulgated West Bengal Thika Tenancy Act 2001. Then 9th April 2023, Badrinaran Kumar and Nimai Chand Kumar claimed themselves to be Thika tenants of the suit property and submitted a return before the Thika controller. This is, Lord, Form A under the Thika Tenancy Act. Then by registered deed of conveyance, the legal heirs of Jitendranath Ghosh, absolute owners, stole the suit property money square. This is how we acquired the property. Then, Lord, 27th of January, on the basis of an order passed by the Thika controller, Lord, the Kumar started depositing the rent from 1981. Then, Lord, 26th August 2010, plaintiff filed an application before the state government under section 13 of the Act of 2001. Lord, state government is actually, Lord, a revisional authority. This is, Lord, against the order of 27th January 2010. Then, Lord, the state government, Lord, remanded the matter back to the Thika controller. That date is missing here. Your Lordships may kindly take note. After the application was filed to the state government remanded it back to the Thika controller for consideration, because we were not given a hearing when the Thika tenancy was, Lord, recorded. So, Lord, now, Lord, Thika controller holds that they are Thika tenants. That is, Lord, 1st August 2012. Then West Bengal Land and Land Reforms Tenancy Tribunal rejects the appeal filed by Money Square. Then, Lord, High Court was pleased to set aside the order passed by the Tenancy Tribunal and further held that Kumars are not Thika tenants. Then 15th April 2014, while, Lord, the SLP was filed by the Kumars, this is the interim orders were passed. If your Lordships, Lord, kindly have a look at page 121 and 123. Your Lordships can keep a note that these are the interim orders by which they were asked to pay the occupation charges. 15th April 2014 and 22nd July 2014. These are at pages 121 and 123 of the petition. Then, Lord, first it was 1 lakh per month, and then it was increased to 1,50,000 per month. Then, Lord, SLP filed by the Kumars was allowed. Decision of the High Court of Calcutta was overturned. Then review petition was allowed. This is the date, Lord, instead of admitted, your Lordships kindly record that this is the date when the review petition was allowed, 3rd March 2021.
Then, Lord, 27th of August 2021, order passed by the Honorable Supreme Court directing Kumars to deposit a further sum of rupees 20 lakhs in the registry of the court, directing Money Square to withdraw a sum of rupees 16,50,000 by way of occupancy charges. This, your lordships will find at page 125 and 126. The order is at page 125 and 126. Then, Lord, 27 July 2022, the Honorable Supreme Court upheld the judgment passed by the Division Bench of the Honorable High Court at Calcutta and dismissed the appeal of the Kumars, holding that they were not Thika tenants in respect of the property and the property was not a Thika property. This is, Lord, 27 July 2022, the final order of the Supreme Court. Then, Lord, Kumars filed a review petition seeking review of this order. This order, the rejection of this application was dismissed. The order is at page 127. But in the order of the Supreme Court, let the Supreme Court gave us liberty, final order, to withdraw that 3,50,000 rupees. And Lord, that order also specifies that, Lord, we are at liberty to initiate appropriate proceedings for the further remedies that we are seeking. That is there in the 27 July 2022 order itself. It is quoted in the impugned order. So, Lord,
Yes.
I'll show it to your Lord.
No, we remember that, yes.
Then Lord Kumar filed a review petition. That review petition dismissed. Then Lord Money Square filed an application where, Lord, they sought, Lord, handing over a possession in the Supreme Court post disposal of the SLP. In that, Lord, an order was passed, which Mr. Mitra has shown to your lordships at page 77 and 78. Your lordships will find 12th December 2022. That application was dismissed with the direction, with the liberty to Money Square to take appropriate steps in accordance with law. This is at page 77, 78. Then, Lord, there was a curative petition which was also dismissed on 28 March 2023 by the Kumars. Now, Lord, the suit is filed. This is 30th March 2023. Our suit is filed. Now, on 1st of April 2023, this dispensation under section 12A was allowed. I request your lordships to kindly have a look at the order at page 130. I will turn to page 131, where, Lord, the court passes an order in IA number 1 of 2022. Has your lordship got that? Right, court, counsel Mr. So-and-so, appearing on behalf of the plaintiff, moves the present application for seeking exemption from reinstitution, mediation and settlement by granting of leave under 12A of the Commercial Courts Act as amended from time to time on the ground that some urgent relief is sought for in order to protect the interest of the plaintiff. I have heard the submissions made by the learned counsel in respect of this present application on great length and perused and considered. Mr. Banerjee, as regards efforts, unreported decision of the Honorable Telangana High Court, etc. Then Lord, kindly come to the second last paragraph. Okay. Kindly, Lord, see paragraph 8 has been extracted. It can be seen from what is extracted above that it is only in case where the suit does not contemplate any urgent relief that there is a bar for institution of the suit without the plaintiffs exhausting the remedy for institution mediation. The expression used in 12A1 of the Act is a suit which does not contemplate any urgent relief. Unfortunately, the learned judge has read the above expression to mean as though only in cases where plaintiff is entitled to urgent relief, interim relief, the provision will not apply. The entitlement of a party to an urgent relief is a matter that would come up for consideration if the suit is numbered and several aspects taken into account. What is required to satisfy under section 12A(1) of the Act is the contemplation of an urgent relief. Then Lord, it says prima facie contemplation, it appears that in the suit contemplates an urgent relief on filing necessary application under Order 39 Rule 1 and 2 read with such and such. Therefore, the leave as sought for by the plaintiff in the instant interrogatory application is granted. Accordingly, the instant interrogatory application being such and such is hereby disposed of. Now, Lord, please turn the page. Then, Lord, Order 39 Rule 1 and 2 is considered, and ultimately an interim order is passed. At page 136, your Lordships will find that the interim order was passed. The defendants and our main agents and assigned we restrain to deal with and or encumber or create any third-party interest in respect of the suit property as described in the schedule plain and the schedule of the instant injunction application up to the next date, that is 11th of April. And therefore, Lord, so far as prayer B, other prayers are not granted, consider hearing of the other side. Now, Lord, this is the order that was passed on 1st April.
Yes.
On 1st April 2023,
Yes.
this order was passed.
Yes.
Now, Lord, on 5th April 2023, they filed this counter suit, which is, Lord, a suit for declaration that they are in adverse possession. That is 5th April 2023. This is title suit number 469 of 2023. And Lord, this was filed in a different court, not in the commercial court. This was filed in the court of 4th Civil Judge, Senior Division, Alipur. Then, Lord, 4th May 2023, the defendants, they filed an application under Order 7, Rule 11 of the Code of Civil Procedure. Now, Lord, there were inter alia 2 grounds, apart from others. One was Section 12A, non-compliance with Section 12A. And also, Lord, it is not a commercial suit.
Your suit number is 4 or 48?
Our suit is 4 of 2023.
It's become 48 in against.
This is.
Oh, I see. TS commercial.
There is a.
Very well. Yes.
Lord, if your Lordships looks at 4th May 2023, so item number, serial number 22, Lord, in the first instance, in an application under Order 7, Rule 11, they seek this point that the suit should be dismissed because of non-compliance with 12A. This point is taken. Then, Lord, kindly see, we file an application.
Is that Order 7 Rule 11 application on record? No.
Yes. Compilation. No, it is not annexed to the.
Not annexed to this.
But I have got the compilation. I can show your Lordship because I intend to show.
Just we want to see how they have taken this point. We just want to see that.
But I show the SLP? That is the final adjudication. Your Lordship will file the grounds and instead of going through all this SLP along.
Lord, if I may just.
Yes, of course.
My learned friend, my Lord, the matter, my Lord, came up from, my Lord, that order, my Lord, rejecting, my Lord, Order 7, Rule 11, my Lord, by way of civil revision, my Lord, dismissed by the High Court. Same grounds, 12A, etc., agitated before Supreme Court and rejected, which are none of that has been, my Lord, annexed here. We want to, my Lord, show those.
Lord, please come to the synopsis first. Page C. Copy the page C first. Kindly see ground B. C, page C. This is in the synopsis.
Hey, Kaushik. We 12:45 fixed আছে না কাউন্সিল থেকে যদি এসে থাকে আমাদের একবার বলে ওটা আমরা অ্যাক্টিভ করে দেবো।
part of synopsis. This is synopsis.
Yes.
Then, Lord, question of law. Your lordships may kindly come to page 25. Roman 5, page 25. Kindly, my lord, the whole SLP is there. After the judgment, the SLP starts. Kindly see ground number 5.
Yes.
This is, Lord, the questions of law.
Yes.
And then, Lord, grounds,
B and E, page 26.
page 26. Kindly turn the page. Grounds B and E.
Yes.
So, Lord, this is the SLP that was filed. And if your lordship wants, I can show your lordship order 7, rule 11. In the original application, this ground was not taken, but a supplementary affidavit was filed, taking this point. And then, Lord, the trial court dismissed this application under order 7, rule 11. As Mr. Mukherjee said, that the matter came up before our High Court in a revision application.
You can give us a copy of the civil revisional order also.
Order to the other. Lord, in the meantime, may I?
Yes, yes.
So, Lord, this application under order 7, rule 11, which was filed on 4th of May 2023, serial number 22. Following that, Lord, we filed an application for occupation charges. This is, Lord, on 19th of August 2023. Then, Lord, order 39, rule 1 and 2, that we filed for occupation charges. Then the affidavits are filed. Then, Lord, kindly come to 26, serial number 26.
Mr. Partho Banerjee, sorry, Mr. Kaur. Mr. Partho Banerjee, we will not be able to take up your matter today. So don't wait. Please inform your senior. Please try to inform Mr. Shatarup Banerjee. We'll give you another date. But you will continue till recess, Mr.
Yes.
Sorry, yes.
So, Lord, serial number 26 is the date when, Lord, order 7, rule 11 gets rejected. Then, Lord, civil revision preferred against that, 13th March 2024. Then, this is, Lord, IA 13 is, Lord, our application for occupation charges. The hearing started. Then, Lord, 21st May 2024, order by which, Lord, the civil revision was dismissed. Kindly have a look at this order. Eta serial number apnar 29. Orderটা নেই আপনার annex করেনি আমি দিচ্ছি একটা স্যারকে একটা কপি তো Lord, in so far as this order is concerned, your lordship will kindly come to page paragraph 7. Your lordships will find the contention raised by the petitioner is recorded.
Yes.
Then kindly come to 9. This is Mr. Mukherjee's, Lord, submission. Kindly come to the last 3 lines. The sentence starting with the word exemption from. Lord, then come to paragraph 17. That is, Lord, at page 10. para 17, the lordships will find the court records that leave under clause 12A was prayed for and was allowed by the court. The court records its finding in some of the paragraph, some of the issues, and then ultimately the court dismisses this application at paragraph 43, 42 and 43, yes. Then, Lord, if we go back to the list of dates, serial number 31, SLP got dismissed. Here is the order. This is not one-line dismissal. This is a reasoned order.
This is the date of dismissal, 14 July.
Yes, 14 June. September, sorry. I stand corrected. 10 September, that is the next date, 32, serial number 32. 14 July is the date of filing. May I place this order, Lord? Just very short order. We have perused the pleadings in the plaint and also the reasons why the applications are filed by the defendants under Order 7, Rule 11 was rejected by the court. Having considered those, the special leave petition is found devoid of merit, the same is dismissed. It is made clear that we have not pronounced on the merits of the suit for either side. Pending applications, if any, shall stand closed. But merit of the suit, obviously, not the eviction at that stage, not 12A. And the defenses, yes, raised in the written statement. Now, Lord, your lordships may kindly come back to the list of dates. After the Supreme Court, Lord, dismissed their application under Order 7, Rule 10, Order 7, Rule 11, where, Lord, all these grounds were taken. Not a commercial suit, 12A violation, and, Lord, the other grounds. Notwithstanding that, they filed an application under Order 7, Rule 10, serial number 33, contending that the suit is not a commercial suit. Now, Lord, this hearing started. Lord, IN number 13 is our occupancy charges. Then Order 7, Rule 10. Then your lordships may. Yes. 29 January 2025, the hearing started of that. Then, Lord, 27 March 2025, what we did, we filed an application under clause 13 of the latest patent before the High Court. Because, Lord, the two suits are being tried in two different courts. It concerns, Lord, same property, same immovable property. So, Lord, we filed an application under clause 13.
Kumar's suit was transferred to the other
yes,
court.
Pursuant to this, Kumar's suit was transferred to the commercial court. This is the order, 27th March 2025, where there was a direction that both the suits should be disposed of within a period of 6 months. So this order was on 27th March 2025. I'll just show your lordships this order later. But this kindly, my lord, mark that there was a direction to dispose of both the suits within 6 months. Then Lord Kumar's filed a review application, seeking review of the order of 27th March. This again was dismissed on 15th May 2025. Then, Lord, Order 7, Rule 10 application was dismissed, Lord, by the trial court on 19th of May 2025. Now comes the application under 12A. Kindly, Lord, mark the date, 23rd May 2025. 1st April 23, Lord, the leave was dispensed with, leave was allowed. And then, Lord, Order 7, Rule 11 for rejection of the plaint on that ground, up to Supreme Court, coming back, Order 7, Rule 10, After order 7, rule 10 is rejected, now 12A. Because, my lord, 6 months time given by the court was, my lord, hanging fire. In fact, they knew that, Lord, they have to defeat that time somehow. So then, Lord, 10th June 2025, the application filed under section 151 of the code, so and so 29. This is for early hearing. Early hearing of their application under 12A. Then, Lord, this early hearing, no order was passed by the commercial court. So, Lord, they filed a civil revision, serial number 42. This is, Lord, seeking expeditious disposal. This is the matter which is now pending before the High Court. It was heard before a bench which released the matter. It is now been assigned. There has been no mentioning for early hearing of this application. Item number 42.
42.
Notice ঠিক আছে anyway ঠিক আছে Then, Lord, 43 is their civil revision, Lord, seeking challenging the order rejection under order 7 rule 10 application. And then, Lord, 2 SLPs were preferred by the Kumar, page 44. এই অর্ডারটা Lord, before your lordships, Lord, sees the order of the Supreme Court which was passed, challenging this order passed in the clause 13 of the latest patent. Kindly have a look at this order which, Lord, was passed in clause 13. Paragraph 24. এটা হচ্ছে আপনার This is, Lord, the order of in ALP 26. Yes.
Serial 36.
Item 36. Yes. Paragraph 24 may kindly be noted. This was the direction that within 6 months they have to be heard analogously and disposed of within a period of 6 months. '23 and 24 may be taken note of. In fact, reading this order, review order, and the Supreme Court order, your lordships will find that Supreme Court really upheld that there was urgency and 6 months time fixed by the court was nothing wrong. Your lordships may kindly, I'll just place it. The review order. This is the review order.
Item 37.
Item 37. But paragraph 15 and 16 18 15 16 18 ever Supreme Court na?
Yes.
And Lord, 2 SLPs to the Supreme Court, one against the main order, the other against the review order. This is the Lord, it says we are not inclined to interfere with the impugned judgments and orders passed by the High Court in exercise of our jurisdiction under Article 136. The special leave petitions are dismissed. However, questions of law raised by Mr. Gopal Sankaranaran learned senior counsel, are kept open for being considered in an appropriate case. Now, not in this case, in an appropriate case.
Yes.
Now, my lord, comes the order passed by the Commercial Court on 22nd July 2024, 25.
That's the impugned order.
That's the impugned. Now, my lord, with this factual background, the two things kindly take note of. The history of litigation, which started with filing of Form A, where they claim to be Thika tenants, declaration of Thika tenancy, then up to Supreme Court, and then Lord, post-suit, liberty granted by the Supreme Court was exercised by filing the suit. My right to sue, which was restored in 2022, the suit was filed within the shortest possible time. I think July 22 is the order, and Lord, the suit was filed sometimes on 31st of March 2023. Now, 12-way revocation has been attempted, Lord, once, Lord, up to Supreme Court, and this is, Lord, the second, Lord, attempt to defer the matter. This is, Lord, on 12-way. This is, Lord, our answer. C30. And
It's already there.
And Lord, this issue has attained finality. There could be no further adjudication on this. The only reason why this 12-way revocation application has been filed after 2 years, because 1st April 23 leave was granted, they have filed it in 2025. After 2 years is only because they want to drag the proceedings. This is where the 12-way situation is. Now, Lord, the other issue with regard to Order 39, Rule 1 and 2. Lord, if your lordships kindly, Lord, take the impugned judgments judgment once.
Yes.
Comes to, Lord, para 39. In fact, the learned judge has dealt with this issue extensively.
Your junior has drafted this list of dates.
Yes.
Very well done. Very comprehensive.
In fact, she has been associated with this litigation from day one, even at the stage of preparation of plaint. Therefore, she knows it by heart.
Internal page?
Internal page 26. The pagination is at the bottom of the page. Lord, kindly take para 31 once, and then, Lord, I'll come back to para 39. Please come to internal page 19. Lord, 31. After gross perusal of the orders and judgments of the Honorable Supreme Court, as dated
Para 31.
31, page 19, 19.
Yes.
After gross perusal of the orders and judgments of the Honorable Supreme Court as stated above, this court finds that the respondents did not object to the interim order dated 27th August 21 or the final order dated such and such passed by the Honorable Apex Court as regards the payments directed to be made by them. It is also admitted that the payment as directed to be made by the respondents herein is payment which pertains to the occupational charges. As regards this court has relied on the averment of the Honorable Supreme Court averred in the order of judgment dated 27 July 2022, which is before closing, we may also take note of the fact that by way of interim orders dated such and such, the appellants were directed to make payment towards occupancy charges. The appellants have made certain deposits further an amount of rupees 20 lakhs in the registry of the court, of which contesting respondents were held entitled to withdraw an amount of 16 lakh 50,000 towards by way of occupancy charges, and the remaining amount was ordered to be invested in a fixed deposit with periodical renewal to be disbursed subject to the outcome of this appeal. The said deposit amount, together with accrual interest is ordered to be disbursed to the respondent number 1, while we otherwise leave it open for the said respondents in taking recourse to the appropriate remedies strictly in accordance with law in relation to any other claim reliefs. Therefore, from the aforesaid, there is no confusion at all that the Honorable Supreme Court directed the respondents to pay the occupational charges in respect of stated amount therein. More so, it can also be deduced therefrom that the Honorable Supreme Court directed the respondents to pay such occupancy charges to the respondent number 1 therein in the present petitioner herein, Money Square Limited. However, in the aforesaid order, the Honorable Supreme Court further held, while we otherwise leave it open for the said respondents in taking recourse to appropriate remedies strictly in accordance with law in relation to any other claim relief. Therefore, it is further to be stated that Honorable Court granted leave to Money Square, the present petitioner herein, to take any other relief, and such directions further asserted in the MA number such and such, needless to reiterate. This is that while dismissing the MA also the same thing was reiterated by the Supreme Court. Then please come to paragraph 39. This is where, Lord, this order 39 rule 1 and 2 is discussed. Page 26. In respect of the contention of power to give direction regarding occupational charges, this court has further relied on the ratio of Bijoy Kumar Manish Kumar and also Order 39 Rule 10 of the CPC, which determines the scope of this court in respect of directing occupational charges. Order 39 Rule 10 of the CPC stipulates, then Order 39 Rule 10 is noted, where the subject matter of a suit is money or the some other thing capable of delivery, and any party thereto admits that he holds such money or other thing as a trustee for another party, or that it belongs to or due to another party, the court may order the same to be deposited in court or delivered to such last name party with or without security, subject to further direction of the court. However, the instant application has been filed under the heading Order 39 Rule 1 and 2 of CPC, but it is settled law that nomenclature of a petition does not affect the substance of the petition, and this court has right to modify and apply proper provisions of law to grant relief in a matter to party, if such relief otherwise needs to be granted. So, Lord, this Order 39 Rule 1 and 2 has been dealt with by the trial court. And it says that there is a provision under Order 39 Rule 10. Misquoting of a provision itself would not non-suit the party. Correct position of law. Then, Lord, kindly come to paragraph 41.
Look at Order 39, Rule 10 once.
Yes. Kindly, Lord, take. Has your Lordship got that? It says deposit of money, etc. in court, where the subject matter of a suit is money or some other thing capable of delivery, and any party thereto admits that
any party thereto admits.
No, kindly see, or other thing
that he holds, yes, but there is such some admission
for another party, or it belongs to or due to another party. Due to another party. Lord, here our contention is that Supreme Court.
What I'm saying, without admission, can you invoke Rule 10?
Lord, we had filed an application under Order 39, Rule 1 and 2. Our contention was, if 151, the court has this power, because, Lord, it is, Lord, balancing the equities between the parties. A property which is, Lord, otherwise, Lord, held by a party over a period of time, he is sitting on the property and, Lord, he is not paying the money. And I have my mean profit is there, which I have claimed in the suit. Lord, a rent equivalent to market rent pre-decree stage can be granted by the court.
We understand 151, but strictly perhaps Rule 10 does not
But
apply.
the issue is, Lord, whether the court had.
Correct, correct. No, we are not on
How-
that. We are also trying to understand whether strictly Rule 10 applies or not.
I say this with little humility that, Lord, in a proceedings, if a party admits, then, Lord, there are provisions, Lord, under the CPC where, Lord, a decree can be passed.
Correct.
It's not, Lord, restricted to deposit of money. The whole decree can be passed. That is Order 12 provision, Rule 6. But here, this contemplates many situations. Order 39, Rule 10. But, Lord, I'm saying that I don't need to, Lord, rely on Order 39, Rule 10. I'm saying 151 itself is sufficient for balancing the equities between the parties in a suit which has been filed. And there is an admission so far as occupation charges is concerned. Supreme Court, Lord, while the issue of thika tenancy was pending, Supreme Court directed payment of occupation charges. Before, Lord, finally deciding.
That they will say 142.
Lord, 142, I can understand, but not as an interim measure. 142 is, Lord, when the matter is finally being disposed of, trying to, Lord, pass an order which is otherwise, Lord, apart from Supreme Court, nobody else can pass. But, Lord, in a proceedings where the issue is pending, and, Lord, the division bench has restored the right to me. In that situation, Lord, 1 lakh and 1,50,000 rupees was directed to be paid by the Supreme Court. Because, Lord, the division bench's order, otherwise, so, Lord, paragraph 39, if your Lordship feels that 39, Order 39, Rule 10 is not the proper, at least, Lord, 151 was there. And in the application, 151 can be invoked, and it was invoked, in fact. Now, Lord, your Lordships may kindly, quickly, Lord, run through this. Lord, please come to paragraph 42.
Aye.
Page 30. Lord, this is, Lord, where the court takes note of the judgment of the Supreme Court. I can skip this for the time being. Then please come to 43, paragraph 43, where, Lord, the judgment cited has been dealt with. Starts at paragraph page 31. This Poonam Kejriwal is the judgment which Mr. Mitro cited. That has been taken note of. 2009, volume 3, CHN 195. Your Lordships will find that at page 32. Then KK Shah. This is also a judgment which has been cited by Mr. Mitro. That has been taken note of. And, Lord, also Gopinath Mukherjee. That is taken note of. Then, paragraph 44.
Poonam Kejriwal is not...
yes, 2009, 3 CHN, Poonam Kejriwal.
Not Supreme Court. That's what
No, it is High Court. High Court.
See, what is written, Poonam Kejriwal is distinguishable to the fact, as the Supreme Court held that since injury was not irreparable.
No, this says, what she says, that there is a subsequent judgment of the Supreme Court which says that this can be granted even at the pre-suit stage, pre-decree stage. That is what she means. Because that judgment has been considered by her. Your Lordships will kindly see that is Manish Kumar. Lord, there are Lord judgments that was cited.
This should be the court, not Supreme Court.
Supreme Court. The Supreme Court has held otherwise in a subsequent judgment, which I'll place before your Lordship. This is, Lord, says, please come to paragraph 44. Therefore, considering the aforesaid, this court has no hesitation to hold that the petitioner here is entitled to get the occupancy charges during the pendency of the pre-suit in as much as in pendency of the per se suit in as much as it is unjust to stay and or occupy in a property without paying any rent. Vijay Kumar, Manish Kumar. This is the judgment that now the next hurdle is what amount ought to be determined. Then Lord, it takes into consideration two factors.
You have a copy of Vijay Kumar?
Vijay Kumar, yes. Yeah. Now, Vijay Kumar. Lord, this is the judgment that I wanted to place before your Lordship. It is reported in 2024.
Property.
That Vijay Kumar, Manish Kumar were cited on the third point, that there can be in a pre-decree stage, market rent could be asked for. This is the third point that was raised by my learned friend. 12A is the first point. Second point is Order 39, Rule 1 and 2, Lord, which I say is not an impediment. And this is, Lord, the third point, that in a pre-decree stage, whether, Lord, market rent can be sought for. Now, Lord, please take note of paragraph 2 first. Kindly come to paragraph 2. Lord, your Lordships will see this was at the pre-decree stage. In fact, the order against which the appeal was preferred is an order where, Lord, the suit was directed to be decided on a preliminary point first, whether it would be a tenancy governed under the Premises Tenancy Act. Lord, that against that decision, the High Court, Lord, our High Court, Lord, took a view and the matter went to the Supreme Court. Your Lordships will get this from paragraph 2. Factual score will appear from paragraph 2 to paragraph 8. In fact, the issue that was preliminary issue that was framed is in paragraph 6. But when your Lordship reaches para 13, but before that, kindly have a look at para 16. What was the rent, contractual rent, the table? What was the contractual rent and what, Lord, rent was being asked for? This is at the pre-decree stage. In fact, my lord, it considers the various definitions in under paragraph 18 with regard to determination. What is the effect of determination? It says that whether it is determined or it is expires by efflux of time, it is one and the same thing. It considers tenancy at sufferance. And all the judgments, my lord, Atmaram properties, starting from Martin and Harris.
Mr. Kaur,
Yes.
shall we continue at 2 o'clock?
Yes.
Yes,
I have
let us.
No, I have no objection.
You please try to complete. Then
Yes.
till 3:30 we can.
No, I won't take
It won't
that.
take that long. Then Mr. Mitru can give his reply also.
Today itself.
If you like, up to you.
I won't like.
No, then don't. Very well, we'll fix
You
it.
have got to be brainwashed by my learned junior. Well, I am waiting for that.
Very well.
So kindly do not ask me to
Are
do
you-
anything without being properly
Are
brainwashed.
you not leaving town for the longish weekend? Yes.
I shall be leaving the court also. It's like that.
Will you be in the abode of peace, at the abode of peace? No.
Not really.
Hmm.
Not the abode of peace, but my lord, the place where Tagore wrote Shesher Kobita
Ah,
and Rakta Koropi,
really? Shillong.
Shillong and Cherrapunji.
Cherrapunji.
The road from Shillong to Cherrapunji is the road where Amit Ray
Yes.
met Lavanya.
Amito Rai, barrister.
The Ray best.
দেখো romantic কাকে বলে
But
দেখো
these things which I read during my student days, but still create a romantic feeling in me at this age. I hope, my lord, the ladies are not taking any note of that.
no, but at the age of 80 he wrote that. The age of 80, can you imagine?
At the age of 80, if he can write that,
Yes.
then I don't see any reason at the age of 86 why I can't feel it.
My lord, under urgent circumstances, may I mention a matter, my lord, for leave to file a memorandum of appeal without the certified.
When was the order passed?
Order was passed on 1st of August. We received the order. We were served with the order on 3rd of August. By the impugned order, my lord, the entire assets, properties, bank accounts of a trust and 2 companies, my lord, have been frozen, my lord.
3rd of August, today you're on the 14th of August. What were you
My
doing?
lord, we had prepared it, my lord. We had applied for the certified.
Urgent matter. Leave granted.
I'm extremely grateful.
this is the situation. And then, Lord, para 22 onwards, the lordships will find the Supreme Court considers, Lord, various judgments, including, Lord, starting with Atmaram properties. 22. If your lordships kindly sees paragraph 23, sorry. 23, Lord, the Supreme Court considers Atmaram properties.
Yes.
Federal Motors. And then, Lord, the paragraph 9 of that judgment is quoted. Then, if your lordships turns the page, paragraph 24, your lordships will see that State of Maharashtra Supermax has been considered. Then, Lord, the Supreme Court under that, Lord, quotes a paragraph which is paragraph 67, and another judgment, Satyavati Sharma, is taken note of in that. Then, Lord, in that paragraph, your lordships will find the other judgments, Mahindra Kumar, Prabhakaran Nair, etc., is considered. And then, Lord, your lordships will find there is a set out of paragraph 68 and 79. 68 and 79. That is, Lord, before paragraph 24. 20 in paragraph 24, just before paragraph 25. If your lordships, Lord, permit me to place para 79, which is set out. Before concluding the decision, one more question needs to be addressed. What would be the position if the tenant's appeal revision is allowed and the eviction decree is set aside? In that event, naturally, the status quo ante would be restored and the tenant would be entitled to get back all the amounts that he has made to pay in excess of the contractual rent. That being the position, the amount fixed by the court over and above the contractual monthly rent ordinarily should not be directed to be paid to the landlord during the pendency of the appeal revision. The deposited amount along with the accrued interest should only be paid after the final disposal of the either side, depending upon the result of the suit. Has your lordship found that? Then, Lord, the court, Lord, goes into the other judgments, which is, Lord, Anchal Mishra, which is taken note of in para 25, your lordships will find. And in para 26, your lordships will, the Vijayan's judgment is taken note of, para 26. And then, Lord, the para 27, the court refers to that Martin and Harris's judgment. And then, Lord, please come to para 28. A perusal of the judgments extracted above, as also other cases where Atmaram properties, one common factor can be observed, that is, the decree of eviction stands fast and the same having been stayed gives rise to the question of payment of mean profit as observed above. The respondent contends that since in the present case no decree of eviction is passed and there is no stay awarded, the question of such payment does not arise. This is the argument which was advanced before your lordship. Then 29. While the above stated position is generally accepted, it is also within the bounds of law that a tenant who once entered the property in question lawfully continues in possession after his right to do so stands extinguished, is liable to compensate the landlord for such time period after the right of occupancy expires. In this regard, we may refer to Indian Oil Corporation Sudhera Realty Limited. Then paragraph 64 is set out. A tenant continuing in possession after the expiry of the lease may be treated as a tenant at sufferance, which status is a shade higher than that of a mere trespasser. As in the case of a tenant continuing after expiry of the lease, his original entry was lawful, but a tenant at sufferance is not a tenant by holding over. While a tenant at sufferance cannot be forcibly dispossessed, that does not detract from the possession of the erstwhile tenant turning unlawful on the expiry of the lease. Thus, the appellant, while continuing in possession after the expiry of the lease, became liable to pay mean profits. Then, then please come to para 30. It is to be noted that the court in Sudhera Observe that mean profits become payable on continuation of possession after expiry of lease. In our considered view, the effect of the words determination, expiry, forfeiture, and termination would, subject to the facts applicable, be similar. And when any of these three words are applied to a lease, henceforth the right of the lease tenant stands extinguished, or in certain cases metamorphosed into weaker iteration of their former selves. Then illustratively, Barton's Legal Treasurer, 3rd edition, suggests the following words as being similar to expire, cease, come to an end. Determination is similar to come to a conclusion, bring to an end. Forfeiture is similar to deprivation, destruction of a right, divestiture of property. And termination, terminate is similar to bring to an end, cease, conclude. Therefore, in any of these situations, mean profit would be payable. Having considered the submissions made across the bar, we note that the disputed nature of the lease deed, in other words, its continuation or forfeiture on account of non-payment, is heavily contested, and stemming therefrom, so is the nature of payment to be made. We also note that the location of the demise premises in the heart of Kolkata, and if the submissions of the petitioners are to be believed, they have been deprived of rent for a considerable period of time. Taking a lock, stock and barrel view of the present dispute, the averments and the documents placed before us, we may record a prima facie view that the respondent tenant has, for the reasons yet undemonstrated, been delaying the payment of rent and or other dues payable to the petitioner applicant landlord. This denial of monetary benefits accruing from the property, when viewed in terms of unchallenged market report forming part of the record, is undoubtedly substantial, and as such, subject to just exception, we pass this order for deposit of the amount claimed by the petitioner applicant to ensure complete justice intercedes the parties. After all, we cannot lose sight of the fact that the very purpose for which the property is rented out is to ensure that the landlord, by way of property, is able to secure some income. If the income remains static over a long period of time, or in certain cases, as in the present case, yields no income, then such a landlord would be within his right, subject of course to the agreement with their tenant, to be aggrieved by the same. The factors considered by us have been referred to in Martin and Harris Supra. We are supported in our conclusion by the observations and guidelines issued by this court in Muhammad Ahmed versus Atmaram Chauhan. We reproduce the ones relevant to the adjudication of the present dispute. According to our considered view, majority of these cases are filed because of the landlord do not get reasonable rent akin to market rent. Then on one ground or the other, litigation is initiated. The tenant must enhance rent according to the terms of the agreement, or at least by 10% every 3 years. And enhancement rent should then be made payable to the landlord. If the rent is too low in comparison to the market rent, having been fixed almost 20 to 25 years back, then the present market rate should be worked out either on the basis of valuation report or reliable estimates of the building rentals in the surrounding areas let out on rent recently. Apart from the rental of property, tax, property water tax, maintenance charges, electricity, for the actual consumption of the tenanted premises and for common areas shall be payable by the tenant only so that the landlord gets the actual rent, out of which nothing would be deductible. In case there is enhancement in property tax, water tax, maintenance charge, electricity charge, then the same shall also be borne by the tenant only. Then, Lord, and Lord, the conclusion is in paragraph 35. So, Lord, my humble submission is this is a case where the lease expired in 1993. After that, Lord, the litigation has taken a toll so far as the owners are concerned. And Lord, nothing was being paid except when we reached the Supreme Court, then Lord, there was a direction to pay 1 lakh and 1,50,000. Now, Lord, much later, when we came to know that the same property which they are occupying has been let out by them to Bevco, and they were getting, Lord, a rent of 18 lakhs something, 18.30 lakhs, which we got to know, Lord, by an application made under RTI, because BEVCO is a government organization where RTI applies. So, my lord, we applied to them and they gave us the copy of the lease deed, where from, my lord, it appeared that they were collecting 18 lakhs and odd per month. And that is exactly, my lord, the material which we produced before the court.
Now they say that it's vacant, lying vacant.
They say that it is lying vacant, but my lord, unfortunately, there is no
neither here nor there.
Neither here nor there. If they are utilized, they are holding the property. If they can't pay the occupation charges, then they might vacate. There is no other reason, my lord, for them to hold it. Whether they can exploit it commercially, the original lease was not to exploit the property commercially. They took on lease because they wanted to run a factory. And that is the basis on which the lease was granted. So, my lord, irrespective of their situation, they have to, my lord, fork out, my lord, the occupation charges.
No, you want to go. Monday, before Monday, you have a word with Mr. Jishnu Chaudhary. Informally come and tell us on Monday, someday following week. Following week, someday.
Yeah, very good.
Otherwise, if we fix a date and then Mr. Chaudhary is in difficulty,
not be here in Calcutta, till the 26th.
Give us a date after that.
He will be here.
So you can talk to him and give us a date so that we can publish, we can list the matter and display it 2-3 days before the.
What about Mr. Chatterjee?
Remember, because I will not remember.
No, Doctor has entrusted me, I'll do.
Yes,
I was told that Mr. Chatterjee is also going to be with
here,
Mr. Chaudhary.
I'm here.
Not in Kenya?
Shevat Kuthai. I look like them, but that doesn't.
I was told yesterday that Mr. Chatterjee is also going to be with Mr. Jishnu Chaudhary wherever he is going.
I see.
This false statement everywhere. I might look like them, my lord, in Kenya.
No, it's a hearsay for me. I have heard it from Mr. Jishnu Chaudhary.
Please don't accept anything that he says.
Yes.
So, my lord, in one word, the learned judge has really followed.
My brother is trying to remember in some matter you had appeared, Mr. Probal Mukherjee had appeared, and you had appeared. We had directed deposit of.
Yes.
Assisting Mr.
Not only deposit, your lordship had permitted us to withdraw the money.
Which matter do you remember?
Yes. I remember.
Arguments were not made.
Arguments were not.
On a concession.
Of course, you have to say that now.
I was assisting Mr. Kaur, so I cannot say anything different.
For whatever it's worth, bring a copy of the order if you can.
Yes, we will.
Have it also, my lord.
I'll hand it up. Lord.
There were no arguments made by Mr. Mukherjee on this point of view.
All right.
Now, my lord, I'll produce it because there also, my lord is right. An occupation charges was allowed by the commercial court. And against that, an appeal was preferred under section 37. Your lordships did not interfere. I'll produce the judgment. Except that your lordships Lord, made some modification of the order with regard to, I think, 2 or 3 months rent, where Lord, which was allowed by the commercial court on some grounds. I don't remember exactly. I'll look into the order and I'll provide.
There was some dispute.
Some dispute.
We said admitted amount.
Yes, admitted amount your lordships allowed for the certain period. And Lord, I think 1 or 2 months there was some dispute. They said that they had paid the rent, and we said that we had not received. So your lordship said that that will stand to trial. I will. I'll get hold of a copy. So, my lord, in short, my submission is that the learned commercial court has really followed the latest view of the Supreme Court and has permitted occupation charges at the rate at which they were collecting from BEFCO. That is the landmark, Lord, which has been a benchmark that has been followed. And Lord, the court says that the Supreme Court says that that can be taken as a benchmark, because either valuer's report or Lord, the rent that is being paid in the locality. That is the view, and this is directly applicable to the property. Now, Lord, this is a case where, Lord, after expiry of the lease, the first time the Supreme Court directed payment of 1 lakh and 1,50,000 in 2014. I think that was in 2014. Both the orders, 2014. Both the orders, one is in April, the other was in July. And that payment direction came to an end when the Supreme Court finally allowed the SLP, allowed the appeal by holding that it's a Thika property. But then on review, when the review was allowed,
by holding that it's a
Thika property, originally, it was by holding that it is a Thika property. But when on review, when the review was allowed, then they were asked to pay 20 lakhs, deposit 20 lakhs, out of which 13 lakhs or 16 lakhs was released initially. 3,50,000 was released when the finally matter was disposed of.
But that direction for payment monthly occupational charge did not continue.
Continue after the review was allowed. It was a bulk amount of 20 lakhs that they were asked to deposit.
And you were granted liberty to
withdraw. We were allowed to withdraw?
No, to approach other forum.
Yes, initiate proceedings seeking appropriate relief. Yes, that was in a final order, followed by the subsequent order also. So, my lord, in so far as occupation charges is concerned, my humble submission is that there can't be any flaw in so far as this is concerned, because there is no dispute to the fact that the property was fetching 18 lakhs. This property was fetching 18 lakhs. At a point of time, they say that they have left. Even if they have left, it doesn't make any difference. That they are bound to pay this price, this occupation charges. The one? Yes. Lord, if your lordships kindly for a moment take page 149. This is a chart. Yes, in fact, your lordships will find that page 144. No, ওই চিঠিটা যেটা দিয়ে forward করেছে, forwarding letter টা. Yes, kindly come to page 139. This is 15th September 2022. Has your lordship got that? This is a letter from BEFCO. And Lord, they annexed certain documents. First is the deed of lease. This annex certain documents. First is the deed of lease. Your lordships will find that in the letter itself.
This is the State Beverage Corporation.
West Bengal State Beverage Corporation. With it's BEVCO, that's how it is in the short form it is pronounced. All state has taken over control of the distribution of liquor. All private warehouses, they have done away with. But this is a corporation which has been incorporated to take control of the distribution of liquor. Your lordship
yes.
remembers that there were distributors earlier.
Beverages is not, my lord, cocoa or chocolate, hot chocolate. Something stronger than that.
Initially,
Yes.
under the excise law,
Yes.
there was a manufacturer, then there was a distributor, and ultimately it came to the local shops for the purpose of selling. So this distribution business has been completely done away with. It has been taken over by this corporation. the following Punjab and some other states where government is controlling the distribution of the liquor.
So this the liquor that's displayed, let's say at the Spencers,
Yes,
comes from them.
it's from them. They are not controlling totally. Everybody has to approach them for buying.
And they only import the imported.
Imported also they do. Or they sometimes they grant license to the
Right.
persons for importing. That is also I'm told that is done. But basically, my lord, the business has been taken over by BEFCO.
Will be of no interest to my brother.
Except for knowledge. Lord, Lord, this is how we got these documents directly from BEFCO, and Lord, they have also Lord forwarded their ledger account to show that they had what amount they had paid. This ledger account is at page 149.
No, but this deed lease mentions that figure.
Yes, the lease, kindly, my lord, come to lease, page 144. Yes, 140. Kindly come to 141, clause 2.
Yes, 144 clause 1 also. You're right.
Yes.
18,30,000.
Yes. Need to just a minute, they can. Lord, whether, Lord, the lease is terminated or not is no way, Lord, concerned with the occupation charges. It has no value attached to the occupation charges. It's my property, you are holding.
An indicator of how much the occupation charge should be.
That's right. That is the only reason why we relied upon this document, to give an impression about the market rate, rather than relying upon the valuation report, market rate. But the Supreme Court, Lord, valuation report was taken note of. So, Lord, these are my submissions with regard to, Lord, the occupation charges. The judgments which my learned friends have been cited, Lord, mostly these judgments are taken note of in the last Supreme Court judgment. This Manish Kumar records starting from Atmaram and, Lord, the.
How would you distinguish Justice Bhaskar Bhattacharya's
I'll come to Justice Bhaskar Bhattacharya. Lord, Justice Bhaskar Bhattacharya's judgment was passed at a point of time when none of these judgments were there, number one. Number two is his lordship relied solely on Order 39, Rule 1 and 2.
That's Poonam Kejriwal.
That is Poonam Kejriwal. Poonam Kejriwal was cited before the commercial court. Poonam Kejriwal was cited before the commercial court. And the commercial court has dealt with it. Now, Lord, may I just indicate two things? His lordship, Lord, only stopped at Order 39, Rule 1 and 2. Did not, Lord, look into any other provision. It was a case where the lower court had dismissed the application and, Lord, the matter had come up before the division bench. Now, Lord, in so far as that view is concerned, that I think was the view of 2013. 2009. That was the view taken in 2009. Lord, I must say that much water has flown through the Ganges after that. And the concept of a person who's occupying a property which is subject matter of an eviction suit has been considered over and over again. And the court has been granting, Lord, orders where, Lord, the court has been permitted to permitting the landlord to get the occupation charges, even during the pendency of the suit. And the reasoning is there in this Manish Kumar's judgment, that otherwise it will be a hardship for the person who is the landlord. He has to wait till the decree is passed. The passing of a decree may take 10 years, 12 years, whatever.
But ideally, it should be deposited in court Then after that, whether you are permitted to withdraw it against security is a different thing. Otherwise, in the event they succeed, it may be impossible for them to recover that.
Lord, on that, I
No, there's a paragraph also cited in Manish Kumar also, Vijay Kumar. That
Lord Manish Kumar, Vijay Kumar, the court directed deposit of rent. There is no dispute with regard to that. But in so far as here, the court has appointed two receivers for the purpose of collection of the rent, and out of which I am permitted to withdraw certain amount. I tell your lordship.
Which court? The commercial court?
Commercial court. Your lordships may kindly take the impugned.
But what rent will the receivers collect if WEPCO has moved out?
No, they will collect, Lord, from the occupiers. From the occupiers. 18,30,000 the occupiers have been asked to deposit.
Who are in occupation?
Kumar.
They are in physical occupation. You don't.
As of now we don't know who are in occupation. But they are trying to hold back the property, because Mr. Mitro's entire submission was that we are claiming adverse possession. A person cannot claim adverse possession unless he is in possession.
So 18,30,000 the receivers will collect, give you how much?
15 lakhs out of that.
And the rest will be
deposited in court. Blood, there are two aspects of the matter. One is an eviction under the Premises Tenancy Act. There, until the decree is passed, in terms of statutory mandate under Section 7, a tenant is liable to pay contractual rent till the decree is passed, post termination of tenancy. But there is a departure under the Transfer of Property Act. There is no similar provision under the Transfer of Property Act. Even in this Manish Kumar case, the controversy which emanated from the preliminary issue which was framed by the court was whether the tenant was governed by the Premises Tenancy Act or not. During that, pendency of that, during the issue being considered, court said you deposit the entire money. But here, there is no controversy that the tenancy is governed by the Transfer of Property Act, because it was a 20 years lease. So, Lord, under the Transfer of Property Act, there being no other provision, Lord, this is a money which is to be deposited. Now, 15 lakhs, the court has permitted us to withdraw. The rent has been assessed at 18 lakhs on the basis of WEPCO's lease deed, and Lord, 15 lakhs we have been asked to. Now, Lord, this, so far as withdrawal is concerned, Lord, after all, Lord, the property is my property. I have been deprived of enjoyment of this property. If I could let out this property, I would have earned this much of money. Lord, the property is there. In any event, that property is there. So, Lord, I am only submitting this, that 15 lakhs we have been asked to, we have been permitted to withdraw. So, Lord, that today, considering the locality of the property and the area of property, is peanuts. In fact, 2018, this rent was being fetched. We are in 25, 2018, yes, 7 years back. Now, Lord, yes, in that Poonam Kejriwal, if your lordships will kindly sees Justice Bhaskar Bhattacharya's judgment, this 2009 3 CHN. Kindly, Lord, come to, this is page 6 of that judgment.
Yes.
The sentence starting with the word, therefore, the mere fact, has your lordship got that? That in the event the suit succeeds in the long run, the defendant number 3 would be required to pay a huge amount of mean profit is no ground to pass a mandatory injunction disturbing possession of the defendant during the pendency of the suit. If that be the position, there is also no ground for passing a direction upon the defendant by way of mandatory injunction to deposit any amount of money as occupation charge as condition of her stay by way of security, because there cannot be a mandatory injunction for payment of money by temporary measure even before passing of the decree of mean profit, the injury being not irreparable and being capable of being compensated in terms of money. I just pause here for a moment. Kindly see Manish Kumar, paragraph 28. Kindly have a look at Manish Kumar, paragraph 28. Whether this rationing, the rationale and rationale, Lord, no, not 28. Sorry, paragraph 31. That part, Lord, around the middle, it says this denial of monetary benefit, has your lordship got that? Accruing from property.
Yes.
When viewed in terms of unchallenged market report forming part of the record is undoubtedly substantial and as such subject to just exception. We pass this order for deposit the amount claimed by the petitioner applicant to ensure complete justice intercept. And the Supreme Court note. Hey, Martin and Harris reference to koto ache?
22.8.
Lord, Supreme Court in pronouncing this judgment relies on Martin and Harris. Your lordships will find that reference in paragraph 31. And Martin and Harris was not pronounced on 2022. It is reported in 2022 8 SCC 527. So, Lord, views have changed. We have moved on. We are not stuck to the point that unless decree is passed, because the concept those days was unless the decree is passed, you cannot give market rent. In fact, I remember one judgment was passed by Justice I.P. Mukherjee, where his lordship allowed market rent at the pre-decree stage. That was not referred to in a larger bench, and the larger bench held that no, unless a decree is passed, you cannot direct payment of occupation charges at any rate other than the contractual rate. But those were all tenancies governed by the West Bengal Premises Tenancy Act. A.K. Shah? Or maybe under the Transfer of Property Act even. I'm not disputing that. I correct myself. But Lord, that was the old view. The views have since changed. Because otherwise, a person has to wait till the decree is passed and an appeal is preferred. That concept has been done away with this Manish Kumar's judgment and the earlier judgment that is referred to, that Martin and Harris. Lord, just for clarity, if your lordships have kindly take the impugned order once. Paragraph 46 of the judgment. Paragraph 46. Internal page 33 of the judgment. This is the two advocates who are appointed as joint receivers. The respondents are directed to deposit a sum of rupees 18 lakhs, etc. before the land receiver within 10th day of per month through any accepted mode of service till adjudication of the instant suit. Out of such deposited amount, petitioner will be entitled to withdraw a sum of rupees 15 lakhs. The balance amount of 3 lakh 30 will be kept by the land receivers in an interest-bearing account with a nationalized bank and shall be renewed periodically, which will be disbursed subject to the outcome of the instant suit. The aforesaid settlement will be rolled on from the next following month, August 25. Then receivers are directed to open current bank account so as to initially receive the amount of rupees 18 lakh. Now, Lord, it's there is a direction by the High Court to dispose of the suit within 6 months. If the parties cooperate, if my learned friend's client cooperate, Lord, both the suits can be heard and disposed of. Not more than 6 months. But they are not permitting, Lord, because in their suit, we have filed an application under Order 7, Rule 11. When I deal with that suit, that's my next point, I'll come to it. They are not permitting, they are not either interested in having their own application heard or our application heard. Their own purpose is because they have now filed a clause 13 again in the High Court. And they are asking for adjournment on that ground that we have filed a clause 13. They want both the suits now to be transferred to the High Court.
Sure.
So, Lord, we are unable to proceed. Either way, any order passed, it is tested first in the High Court and then to the Supreme Court, and if it is passed by the High Court, to the Supreme Court. So we have already been up and down to the High Court and Supreme Court. Now, Lord, I come to the question of being sued for adverse possession. Lord, kindly take 2 dates, Lord, from the list of dates. 93, Lord, the lease expired. And 2003, my learned friends, Lord, filed the Form A. That first date is the second one, the second in the serial, 30th November 1993. And Lord, the serial number 4, Bodrinaran Kumar claimed to be Thika tenant. Now, Lord, broadly speaking, when they adverse title is when a person claims title. Adverse possession, when a person claims title which is adverse to the owner. In 2003, he applied for the property being vested to the Thika control. So, Lord, up to Supreme Court in 2022, the clash of title was between the state and my clients. Because my clients were seeking, Lord, restoration of their right to property. In July 2022, Lord, the Supreme Court restored my right. So between 2003 and Lord 2022, no adverse title was ever asserted. And between 93 and 2003, also, no adverse title was asserted. Now, my Lord, under the relevant provisions of the Limitation Act, Article 65, an owner loses title if for a period of 12 years continuously a person is claiming adverse title. So, Lord, the owner has 12 years to recover his property from the time the adverse title is claimed. Now, what happened was, up to 22, they were claiming as a tenant under the state. There was no alternative case pleaded before the Supreme Court or in any forum that they are in adverse possession. Their entry is legal because, Lord, it was on the basis of a lease. From 93 to 2003, they never claimed any adverse possession. And from 2003, they claimed to be Thika tenant up to 2022. Now, Lord, we have filed an application under Order 7, Rule 11, saying that suit is premature. Because 12 years, they say that the cause of action has arisen in 2022. So they have to wait for 12 years before they can file the suit. that order 7 rule 11, the hearing is concluded practically, we have to just give our reply. At that stage, this pendency of this appeal and pendency of ALP is shown to seek adjournment. So this is where we are with regard to the adverse possession issue. I just gave your lordship a broad overview. I don't want to, Lord, enter into the area, but Lord, an adverse possession has to be decreed by a court to mature into an adverse title. So today, one can't say that there is a possibility of my title being declared as adverse, therefore I would not pay occupation charges. So, Lord, my submission is short. So far as, Lord, the 12-way issue is concerned, that has become final. So far as Order 39, Rule 1 and 2 is concerned, I have made my submission that court has ample power to grant occupation charges. The other point was that with regard to no occupation charges can be allowed unless there is a decree. That I have dealt with. Now, Lord, the views are totally different. That used to be the view, but now the views are totally different. And adverse possession is the other point, which I say is wholly premature at this stage. So, Lord, these are my submissions, and I don't deal with these cases because, Lord, most of these cases has been dealt with, Lord, by the Supreme Court in the latest judgment. So, Lord, I don't independently deal with these cases. So, Lord, these are my humble submissions.
Mr. Mithro, when will you come back?
Anytime next week, whenever it's convenient to your lordship, anytime. Yeah, 26 তারিখে।
না কেন কোর্ট কথা শুনবেন না, ও তো কোথাও যাচ্ছে না, কলকাতায় আছে।
Roughly 45 minutes?
Yes, it's definitely not that. ওর সাথে না রাখলে কি আমি বলতে পারবো না, তুমি বলো।
বলো না
না না,
তো অন্য নাম্বার রাখছেন।
He wants 2 hours.
No, 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 no. Even if he wants it, but I don't have the energy to stand and.
He is trying to contradict himself. Whatever he said.
I'm a victim of circumstance.
Whatever he said just a few minutes ago, that the hearsay, I said that is my hearsay, that's not right. Now he is trying to convince his senior.
তুমি নেক্সট উইক থাকছো না একদমই?
মঙ্গলবার অবধি আছে। মঙ্গলবারের মধ্যে দিয়ে দিন না, মঙ্গলবার অবধি আছে।
Wait, give us a date, whenever.
সোমবার মঙ্গলবার করে দিন।
তুমি ডেটটা বলো, তুমি 29 we just said. My learned Juni is asking for 29th.
Like this Monday, are you there?
I am here.
Monday, Tuesday, he is here.
Monday, Tuesday.
This Monday, Tuesday is here because otherwise the court is also going to.
Tuesday?
সোমবার দিন করবো।
ঠিক আছে, ঠিক আছে। Tuesday.
Don't drag it anymore. কি হচ্ছে? জজ সাহেবদের একটা ইয়ে আছে তো, কি কথা? Tuesday will be all right for you, lordship.
শোনো। Tuesday এটা টপিক করে
একটা জিনিস নিয়ে
কমার্শিয়াল না।
না
Tuesday তো কমার্শিয়ালি। Tuesday টপিক করে তো টাইম দিতে
তোমরা অ্যাপ্লিকেশন করেছো? অনেকদিন ধরে টেনেছো?
অ্যাপ্লিকেশন যদি থাকে
আরো তো টানতে হবে।
দেখি অ্যাপ্লিকেশন নিয়ে আছে।
হ্যাঁ তো স্যার
Senior counsel representing the appellants. Oh, you had concluded on the last occasion.
Yes.
Oh, সেটা রেকর্ড হয়ে গেছে, sorry. Mr. Joydeep Kaur, learned এটা কেটে দাও প্রথমটা. Learned senior counsel representing the respondent concludes his submission. Paragraph on the request of Mr. Mithro, learned senior counsel representing the appellants, let this matter be listed again on Tuesday, date the
19th.
19th,
19th.
under the same heading.
Much of.
But it is understood that we are hearing out the appeal.
Yes, Your Lordship
Yes,
indicated.
yes, it will be application to.
Your Lordship had indicated that on the last.
Yes, now.
But in the morning.
It will be in the morning. Commercial matter, Tuesday is a commercial day. শুনুন না, এই আলাদা আলাদা পেপার
আমি বলেছি 8 ঘন্টার মধ্যে
মনে আছে পয়েন্ট গুলো মনে আছে আর্গুমেন্ট শেষ করে ফিনিশ করা করছে
But the other matter, my lord, I'll just talk to Mr. Chaudhary and tell your lordship right away. Right. Not in town today. I think I know that.
No, you inform us on Monday.
I'll do it right away, my lord, so that your lordship has the weekend to even find.
It won't help. Over the next 3 days, nothing will happen. So you can tell us on Monday. No?
I'll finish my duty, my lord. I think well.
Call the rest.
Yes, sir. না আমার সবসময় আছে
Your Lordship, item number 3 was supposed to come up after this ACD 1.
Mr. Banerjee indicated he won't be here after 2 o'clock.
Not today, it will be taken up. Yes, we were waiting.
Which one? 3?
3. It was
Yes, but ensure that on the next day, be fair to Mr. Banerjee, he was there.
Yes,
All of first half, he was there. It is not always possible for us to take up every matter. So next day to complete it, please tell him.
On Tuesday.
Not today.
My lord, I'm led by Senior Counsel Mr. Nilanjan Bhattacharjee.
In 6.
In 6, my lords. Appearing for the petitioner in this particular matter, my lords. My lords, he is severely ill, suffering from very high fever, my lord. I'm praying for not today.
On the ground of illness of learned senior counsel appearing for the appellant, let this matter stand adjourned for the week.
Lordships, I appear for the respondent number 1. My appearance could be recorded.
No, give your appearance. Ki bole chat box.
Very well.
In the chat box.
Grateful, Your
Grateful.
In item number 8 to 10, I am led by Mr. Anindya Mitra, Your Lordship, but he is not available. This is an assigned matter, Your Lordship. But he is not available till 31st of this month, Your Lordship. So I was humbly praying that may it be fixed on
appellant.
I am for the appellant, right?
In all the matters?
8 and 10. 9 is somebody representing for the appellant, but Mr. Mitra is leading me in item number 8 and 10.
Very well.
So if it can be kept up on
2nd September, 4th.
Because Your Lordship takes up non-commercial of appellate side on Thursday.
As requested by learned counsel for the appellants in MAT 812 Akshoke Corporate of 2024 and MAT 847 of 2022, let these matters stand adjourned and be listed again on September 4.
Deeply obliged.
They can call. Not today. Chilo, puro সকাল ঠিক ছিল। Dismissed usual order, Abhijit. এটা এই এক্ষুনি রেস্টোর হয়ে যাবে, দৌড়ে দৌড়ে আসবে। এটা কি কমার্শিয়াল?
Wait, please, my lords. I had concluded my submission. Mr. Shwetarup Banerjee would have, my lord, started.
Oh, yes, rejoinder.
Rejoinder, my lord.
Today you have to be a little what to do. I'm sure he's run away by now.
Deemed Friday, my lord, I understand. We'll come back, my lord, any other time.
Not today.
My lord.
Number 3.
Item number 3, Mr. Chitopriya Ghosh is appearing for the respondent. He's on his legs. I'm praying for not today, my lord.
Lord, can it be on next Thursday? Tuesday, I am in some personal difficulty.
Accommodation, লিখে দাও তাহলে। Accommodation is paid for on behalf of the respondents. Paragraph. As requested by learned advocate for the appellant, comma, list this matter once again on সামনের বৃহস্পতিবার করে দাও। হয়ে গেল? যাও।
My lords, if I may interject, my lords. My lords, if I may interject, my lords, my lords are not audible. My lords, I'm opposing the mentioning.
Pass over.
My lord, I seek an accommodation.
On behalf of?
On behalf of Mr. Shuddhaswata Banerjee.
Which party?
Respondents number 2 to 5.
Pass over.
For the appellant, your lordship.
Appellant?
Your lordship.
They are seeking adjournment. 1 second. Number 3, you are for the appellant.
Appearing for respondent number 13 and 14.
Yeah, Astuju. You are for the appellant.
Yes, your
They are
lordship.
asking for time. Let it be not today.
Lord, you was led by Mr. Chaudhary. I was led by Mr. Chaudhary. Shoboshachi Chaudhary is appearing in this matter.
Time for that, sir. Your Lordship. We've been told
We
that
have been
Mr.
told
Chaudhary
he is
probably
not
not
in the court.
Yeah, humbly
Yes,
praying for
just
his
now.
What we are suggesting not today.
Yes, your
Yes,
lordship. His clerk. Yes, your lordship.
Cholo.
My lord, appearing on behalf of the petitioner, my lord. My lord, praying for a short passover, my lord.
Passover. Passover.
8 and 9. Item number 10 and 11. Item number 12.
12.
11 and 12. 11. 10, 11. 12. Oh, no, sorry. Item 12. 13. 14. In item number 14 and 15, your lordship, I appear on behalf of the petitioners. On behalf of the appellants. Your
Yes.
lordship. Yes.
You want to start it?
I can, your lordship.
No, don't do it. Other side is not here. Pass it over once.
Item 18. Item 16. 17. 18. 19. 20. 21. 2. 3.
পুরোটা ডাকবে
25 and 26, 27, 28 and 29, 30, 31, 32, 33, 34, 35, 36, 37, 38, 39, 40, 51.
Lord, for the respondent, my lord, just my lord, this arises out of a dismissal of a originating someone's suit, my lord.
Out of a
dismissal of an originating someone's suit.
41.
41.
Yes.
So, my lord, I'm not sure, my lord, whether it will be an appeal from decree or not, because it's.
They are not here. Pass it over, Mr. Gupta.
42, 43 and 44, 45, 46, 47, 48,
My lord, I beg to appear for the appellant, your lordship. I'm seeking a short passover, your lordship.
49, 50, 51, 52, 53, 54, 55, 56, 7, 58, 9, 60, 61, 62, 63, 64, 65, 66, 67, 68, 69, 70, 71. Second call, possible by item number 1.
My lord, I appear.
Review applicant.
My lord, lordship's order starts at page 18. My lord, relevant portion with which we are concerned, my lord, limited point, my lord. Para 31 at page 30.
First time. No, it's not served.
Yes, we have served. I'm served. My lord, this is, my lord, the point is, my lord, lordships have held, my lord, that the learned judge did not have the jurisdiction, did not have the determination on that day. And my lord, the point,
But I had made the submission that, my lord, at that point of time, the pecuniary jurisdiction was, my lord, it was a non-commercial, no question of commercial. But, my lord, we did not have the notification. I had said that, my lord, it can be easily ascertained. So the notification was not there, but I had made the submission. But be that as it may, my lord, I thought they would concede because, my lord, the advocate on record was.
Where's your affidavit of service?
In fact, my lord, I had said that there is also an order of Justice Mojumdar, which, if they press that point,
This is service on the advocate.
yes, advocate appearing in the appeal, my lord.
How do you know after disposal of the appeal he is still authorized?
My lord, he has accepted.
Somebody on behalf of
Very
the
well, but I'll come back.
After all, review if we change.
Yes.
Affidavit of service filed in court today be kept with the records. Paragraph. This is an application for review of a judgment and order dated July 23, 2025, whereby APO 84 of 2023 was disposed of by this court. Paragraph. The review application has been taken out by Garden Rich Shipbuilders. By
Marine Craft Engineers.
I see. The respondent in the appeal. By the respondent in the appeal. Stop. Let service be effected directly on
Garden Reach
Shipbuilders and Engineers Limited, which was the respondent in the appeal.
Which was the appellant
in the appeal. And affidavit of service be filed, fresh affidavit of service be filed in court on the next day. Next Thursday. Or when? Next Wednesday.
Whenever Lordship takes.
It's non-commercial tho.
Wednesday is commercial. This is. But they have come.
My lord, Mr. Devnath Ghosh is appearing on his request. I'm praying for not today, my lord.
It would have saved us a lot of trouble if you came when the matter was called on. Not today, Karo. No service is required.
I'm extremely sorry, my lord.
We'll take back the affidavit of service, or should it be there?
Affidavit of service, this will be on record.
Item number 2.
My lord, Mr. Shobhan Banerjee is appearing in this matter, my lord. He's on his way, my lord.
For whom?
He's coming from court number 14, my lord. He's on his way.
Speech is defective.
My lord, I'm praying for a short passer.
For whom is he appearing?
For state, my lord.
State. Item number 2.
Item number 2.
He bole na.
Item number 2 is ours. No.
State is not a party even in item number 2.
My lord, my apology, my lord.
Hey.
He instructed, my lord.
Hey, usual order. Usual order jana dismissal jeta. And nobody. Huh?
Number 4 and 5.
4 and 5, Your Lordship, I appear on behalf of the respondent. Your Lordship had heard this matter with regard to assignment of the arbitration clause.
Remember, Mr. Anirban Rai was appearing.
Mr. Shatru Banerjee was on the other side.
My lord, I'm for the petitioner, my lord. I just prayed for.
Item 2.
Item 4 and 5.
Who are you for?
Item 2, Lord. But not state, wrongly stated, Lord.
Then why do they confuse us, Mr. Banerjee?
But I'm sorry, Lord, with folded hand, Lord, I'm praying apology.
Not today, Kureda. For whom do you appear in item 2?
Appellant, because your Lordship knows, without certified copy, I have taken leave from your Lordship.
No, we don't know.
Madhya Pradesh government.
Madhya Pradesh government?
Yes.
Unique Entrepreneurs and Finance Limited.
Yes.
মধ্যপ্রদেশ গভর্নমেন্ট স্টেট অফ মধ্যপ্রদেশ আমি কোনটা না না টু
নন কমার্শিয়াল বেঞ্চ চলছে
ও আই সি আই এম সরি
কি বলবি বল?
না সরি সরি ম্যাডাম সরি আমি অ্যাপোলোজাইজ
ওই যে যেটা ছিল ডিসমিসড,
কমার্শিয়াল প্রসিডিং
তাতে কি হলো? অ্যাসাইনমেন্টের হলে কি যায় তার মতো করে।
আমাদের
4 and 5 not today. What do you want?
Not today.
Not today.
My lord, 4 and 5, my lord, this matter needs to come in the commercial bench, my lord. When it was heard by the erstwhile bench, my lord, it was in the commercial division. Thereafter, my lord released this matter, my lord.
Commercial?
Yes, my lord.
Relating to higher purchase of equipment.
It is a commercial division, my lord.
Sir, we are commercial, non-commercial both. And this is specially assigned to us.
Oh, that's why it's there.
ওই লিস্টে দিয়ে দিও, ওদের তাহলে চিন্তাটা যাবে। হ্যাঁ, it will be listed under commercial.
Much obliged.
Six and seven.
My lord, item number 6 and 7, my lord, I beg to appear online, my lord. These are, my lord, the Lamartine School matters, my lord. On the last occasion, my lord had directed that the report which the original side is, I apologize for joining online, my lord, very sorry, my lord. There was a direction that the report of the registrar be taken by us, my lord, and circulated to all parties. We have done so, my lord. If my lord.
Not today, I'm being led by Mr. Dutt.
Not today, not today.
Report of the registrar, my lord.
Next matter.
In 8, I am the respondent.
And 9?
9, my lord, I am the appellant.
The other side is not there. Not today.
But
Both matters not.
These matters are no longer assigned matters because your lordships have heard this matter initially. Thereafter, my lord was sitting with Justice, Honorable Justice Rai Chattopadhyay. That time, those matters were released for assigned. Now, both lordships are sitting
So
together.
it will be listed under the appropriate heading. এটা specially assigned নয় বলছে। এই হেডিং থেকে বা দেখে নাও, দেখে হেডিংটা পাল্টে দিও।
And also, my lord, both these appeals were filed under commercial. I have no issue, my lord. I just pointed out.
No, tell him.
এগুলো না কমার্শিয়াল ম্যাটার দুটোই, এই দুটো কমার্শিয়াল ফাইল হয়েছে, সেই জন্য বলছিলাম কমার্শিয়াল।
অ্যাসাইন নয় বলছে, চেক করো।
I thought 10 and 11. But not today.
10, 11?
No, my lord. 9, 10, 8, 9 are not.
Yes.
There are two appeals. Mr. Surajit Nath Mitra was
What are
to
you
start.
doing here? You're supposed to be in Ladakh.
These rumors I have heard, but next week, not 22nd, the last week of August. Mr.
Remember Dhanbad property.
Yes,
Dhanbad property. We remember, but then nobody's there.
Mr. Mitra was to begin.
And today, anyway, in 10 minutes we'll rise. Not today, not today.
Yes. No, this is good. I appear for the appellant in this matter. This matter, your lordships had been pleased to consider before Justice Babulal Jain's order that the vicarious liability, the state has been held liable. The lordship had seen the order, there was no reasons, and was about to pass an order. Thereafter, we were told to serve them once again. 1987 suit, the appeal is also of 1997, and we have served Manat by way of
Memo of appeal to the.
No one is appearing. Affidavit of service, Manat. Pursuant to my lord's order, we have served them, and by substituted
Ex parte decree, Mr. Ghosh, ex parte decree.
Yes, there was ex parte against the state. What had happened was there was a writ petition. A writ petition had been filed regarding, my lord, some levy to be taken in respect of some railway carriage goods. Thereafter, the division bench in the writ petition had made some strong observations saying that the officers liable should be held personally liable. Then a suit was filed, and the officers and the state, my lord, were only this advertisement is in some other language. Tamil.
Oh, paper publication has been made.
Yes, my lord. That we have given.
Telugu. Tamil Nadu. Tamil.
And in
the paper
the only other fact I need to bring to my lord's notice is a contempt petition had been filed, and there's an order of Justice Rumapal, 7th August 98, where the money was deposited in court. So we have deposited the 4 lakhs it was.
In the paper book, where is the decree?
Yes. And the judgment is the first page 1 to 6 is the judgment. This is a completely typed copy. I'll just tell my lord.
Paper book 1 to 6?
No, man, that is the Justice Pal's order. I'll tell my lord.
25.
75.
75.
7. 1 0. I had it in my memorandum.
Excuse me, एक paragraph, एक pata. There will therefore be a decree.
অর্ডারটা পাচ্ছি না।
Right. But okay, but the পয়সা তুলে নেওয়া। Mr. Ghosh.
Yes.
We'll set aside this order, remand it, you withdraw your money from the court.
Okay. They have also not taken...
Pursuant to our earlier order, dated June 25, 2025, substituted service has been effected on the respondent number 1. Who was the plaintiff?
On the plaintiff, Vikas Trading Proprietorship.
On the respondent number 1 / plaintiff by paper publication, as would appear from the affidavit of service filed in court today. Paragraph. The decree appealed, the decree impugned, the judgment and decree impugned in this appeal was passed on June 3, 1996. Stop. It was for a sum of rupees 2,93,600 against the appellant.
June 3, 26.
It was. No, stop. It was an ex parte decree against the appellant. Tarpore for a sum of. Ex parte decree for a sum of, along with interest thereon at the rate of 18% per annum. Stop. Paragraph. The judgment portion reads thus. Page 75 or 76 set out. Bracketed portion. Paragraph.
Okay.
In spite of service, nobody appears for the respondents. Paragraph. The appellant is aggrieved by the decree and, in our opinion, justifiably so. Stop. There is absolutely no reason, or in any event, no adequate reason in support of the decree. Stop. The decree is set aside. The judgment and decree is set aside. The matter is remanded for fresh adjudication by the learned single judge having determination in the matter. Paragraph. We are told that pursuant to which order?
7th August 1998,
Where is
page
that?
4.
Page 4. Pursuant to an order dated August 7, 1998, passed by a learned judge of this court in a contempt application.
Yes.
It used to be registered as matter number in those days.
In 98, 97.
In a contempt application being matter number 275 of 1997. Ki bolna shuru karna?
But the challan is at page 6, the typed copy. Yep. 4,94,000. 4,04,000.
Comma, the appellant deposited কত 4 lakh?
4,04,000.
Rupees 4, 04, 000. 4, 04, 000. With the
It's
registrar original side.
page 6.
With the registrar, original side of this court, original side, Calcutta High Court. Original side, Calcutta High Court. Stop. Since we have allowed this appeal, the appellant will be at liberty to withdraw such amount along with all interest that may have accrued thereon after deduction of any applicable charge that may be applicable charge commission.
Poundage.
Deduction of any applicable poundage.
I think, I don't know if it's still there.
Poundage. Paragraph disposed of, appeal disposed of.
Great.
Priority appeal কাটান করে
বলো
Lordship,
before rising, Lord, but I have committed a wrong because I was on legs in court number 8. That is
committed no wrong, but
Lord, alibi. That should not be alibi. But Lord, my junior online, but at that time, Lord, the line was disconnected or dropped. My Shambhuddha Dotto. Lord, this is the appellate side, madam, item number 5. Lord, Lordship, kindly pardon me, Lord. But, and I learned friend is appearing for other side. But if your Lordship kindly, Lord, kindly give me a chance on Monday, Lord, I will.
order করতে বারণ করো, not to request.
Lordship, my item number 2, unique entrepreneurs was made, was dismissed for default.
Which one?
Item number 2, unique entrepreneurs versus really agri-tech.
Corona. দুইটা করোনা,
Much
not
obliged.
today. Sure.
I've got concession, Lord. I'm very much obliged to Lord.
It has nothing to do with independence.
We'll come back. There is a request from the bar to us, but we are here. It's up to you.
Can't be up to me because your lordships have been requested. And I have come because this is not a professional matter. Your lordships have been kind enough to give me the opportunity of assisting your lordship. That is why I'm here.
We seek your advice. What should we do?
Lord, I would submit, Lord, considering my association with all of your lordships, kindly not go for a confrontation with the bar.
We'll fix a date then. Dekho. Next Wednesday. Roughly how long, Mr. Shengupta, should we keep for you?
45 minutes.
45 minutes. Can second half नहीं? বুধবার বলছে 12:30 বলছে সেকেন্ড হাফে সব ফিক্স হয়ে আছে সেই জন্যই 12:30 অন্য কেউ বলবে কি আর হ্যাঁ হ্যাঁ we can keep it next Wednesday at 12:30 so that between 12:30 and 1:15
Yes.
45 minutes we can give you.
Just your lordship. Next
Wednesday, the date will be 20th.
20th. Lordship, give me a second. Yes. Oh. Lord, I have already.
এই অন্য কবে তুমি 3:30 কবে অপশন দাও না আবার ফার্স্ট টোয়েন্টি-ফিফথ আগস্ট একটা রেকর্ড অর্ডার করো আর অর্ডার রেকর্ড করো in view of the request from the bar, comma, we do not take up this matter today. Paragraph lists this matter once again on August 25, marked 3:30 p.m. Thank you.